This is an update to the Mark Carter case. He is the pro se employee thief. It's quite long, can get annoying at times. So if you would like to fast forward, the first hearing runs from just a second until 2:52:23. The second hearing runs from there until 3:36:34. So if you want just the new stuff, fast forward to 3:36:34, and I put links to those things in the description.
What's that?
I can't do September.
Why?
I have family that comes in around that time, and we do a lot of. We're never around the house at all with the kids because it's right at whenever they're at school, we're visiting, and when they're not at school, we're out and at one of the lakes here in Kansas visiting, and that's just the month of September for our family. That's an every year occurrence.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Mark Anthony Carter. It's case number 2023 CR 194. Mark Carter appears on his own Zoom, apparently still representing himself pursuant to a previous announcement that he wanted to self-represent. Amber Norris appears for the state. This matter comes before the court at this time for evidentiary preliminary hearing. I trust the state's ready to proceed, Ms. Norris?
Yes, Your Honor.
All right. Mr. Carter, you're ready to proceed?
Yes, I do want to reserve all of my rights at this moment as well. And I do request that the court excuse the witnesses in this case to be only to only come into the call whenever they're being called to testify and not to be able to hear the proceedings themselves.
All right. I understand, Mr. Carter. Ms. Norris, who will your first witness be?
Your Honor, I think I'll start with Kim Bishop.
All right. Mandy, if you could put all of the other witness participants in a waiting room until it's their time to testify.
Thank you.
And Your Honor, just I think kind of housekeeping matter. We do not yet have a signed waiver of counsel, which normally we get for purposes of providing discovery to those that decide to remain pro se.
Counsel, he waived orally on the record.
Okay.
Your record should be complete that he has waived the assistance of legal counsel, and he made it quite clear that he wanted to represent himself at a prior proceeding in this case. So,
and Your Honor, I do have notes to the effect that he did a waiver.
I've been muted for some reason. I can't hear anything anybody's saying.
but you may want to turn up your volume, Mr. Carter.
No, it's back on now. It came back on now. I haven't touched anything or anything.
Go ahead and complete your sentence.
I couldn't hear anything that y'all were discussing there.
All right.
It was my mic or my audio was muted towards me from your direction.
All right, Ms. Norris.
Your Honor, we have not provided discovery to the defendant. We were waiting on, well, we generally get a signed waiver. And I do know that he did say that he wanted to self-represent. So I just wanted to make it clear that we had not received a signed waiver, and that we also had not sent discovery. And I'm not quite sure how we're going to accomplish that with the defendant, but I just wanted the court to be aware of where we're at.
Very well. All right, Ms. Bishop, you'll need to join with both audio and video at this time.
Okay.
You can take your hand down. Okay. All right, Ms. Bishop, I'm going to administer an oath to you at this time. If you'd raise your right hand, please.
Okay.
You do solemnly swear that the testimony you're about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, sir.
Ms. Norris, you may question the witness.
Thank you, Your Honor. Please state your name for the record.
Kimberly Lynn Bishop.
And Ms. Bishop, what is your, or I guess what was your employment status December 2021 to basically April of this year?
With Total Installation, co-owner.
Okay. And
Majority.
did you have something else to say?
We're split with me and my husband are split. I'm 51%. He's 49%.
Okay.
So
And where is your business located?
right now we're running it out of our house in Andover, Kansas.
Okay. And in December of 2021, did you have more than one property that the business basically operated out of?
We are storing stuff, and we still are storing stuff at 13th and Andover Road, and also at our home, which is Kellogg and Andover Road approximately.
Okay. And those two locations that you just mentioned are within the city of Andover and within Butler County?
Yes.
And your co-owner, what is Total Installation?
We're a business that started in 1995, doing commercial interiors. Is a shortened sum it up. We did or do commercial flooring, commercial carpet cleaning, and a Division 10, which is like architectural accessories. And there's one more. Oh, office furniture installation, which is how we started it back in 95. So
Okay.
kind of those 4 areas.
All right. And are you familiar with Mark Carter?
Yes.
And the person that you identify and that you're familiar with as Mark Carter, do you see that person on the screen today?
Yes.
And can you explain the backgrounds, colors, that sort of thing, of Mr. Carter?
Can I describe?
The background, what
relationship?
color of shirt he's wearing, that sort of thing.
Okay. His background is white wall, and he has a turquoise colored shirt on.
Okay. And does he have facial hair or no?
Yes.
And I would ask that the record reflect that the witnesses identified the defendant, Mark Carter.
The record so reflects.
And why are you familiar with the defendant?
He was an employee of ours.
From when to when?
He started officially, I think it was January of 2020, and through December, like November, December 2021.
And what was the reason he's no longer an employee?
There's a lot to it, but basically he ended up stealing a lot of our property that was product. He stole a bunch of our equipment and also a bunch of tools.
And did you report the theft to law enforcement?
Yes. He had asked to borrow our 20-foot box truck, probably late October, early November of 2021. And he did not return the box truck when we needed it, and he just abandoned it, and we had to go find it. And so we had damage to that also. And that was December 1st, I think, was when we recovered the box truck. And
Okay.
that we went to and we filed a police report probably the next day or the day after that, if I had to get all the information gathered, but I think it was the very next day.
Okay, so December of 2021, you made a theft report for the box truck and other items, or at that point, was it the truck or not?
We
truck?
had the truck back, but we reported that he had taken it and not returned it and would not return it. That was documented, but we had the truck when we filed the report. We just knew he had our equipment, and that was the main thing, was we wanted our equipment back. Oops.
And in December of 2021, do you recall which item or which piece of equipment that was missing that you knew of specifically that you reported?
It was I think we made a list of the biggest 6 that we knew were gone, including gosh, I'm gonna have to see if I get these right.
And if your husband Tim is actually better suited for the equipment questions, yeah,
that's
you
probably
can certainly let me know that.
It's probably a good idea. Although I know it was a shot blasting machine that was, when we purchased it, was close to $60,000. It was another one we call the National, is a floor scraping machine. It was our big equipment that we use for work. That's and any other questions, if I think of, I can answer. But yeah, Tim can go over the equipment probably better than, more knowledgeable about it than I am.
Okay. And so you make the report to law enforcement, and that's back in December of 2021. At that point, is there much else that happens for a while?
No, and I didn't know what to expect after we filed the police report. We were at the time still like neck deep in a lawsuit down in Oklahoma with a contractor that we had. It's been part of our lives since 2016 is when it was filed.
Objection.
What's the objection, Mr. Jordan?
Relevance.
Well, I'm wondering what the relevance is too, Ms. Norris. If we could just focus on the theft items involved in count 1.
Your Honor, I don't know, because she just started talking about it. So without, I guess, maybe letting her continue a little further, I really can't
Why don't
say.
you focus a question that she can answer? Restate a question, please.
Your Honor, I think my question was, if, once they made the police report, if anything regarding if anything significant, if anything happened for a while after that police report was made.
No, and we didn't hear from the police department or know what to do from that point on, or at that point.
Okay, but then did you have contact with the police again at a later date regarding that initial police report?
I contacted them again when I saw a piece of our equipment that was going up for auction within a couple days.
And where did you see it, and how did you know that it was yours?
I had been periodically checking, like, to see if our stuff was up for sale somewhere, like Facebook Marketplace. I found the piece of equipment was on a site called Purple Wave, and I was just searching for the equipment by the name and for sale, and it was up for sale on Purple Wave under, I don't think Mark used his real name. I think he used a name of Matt Carter instead of Mark Carter, but the serial numbers matched, the picture matched, and I think his address was in the picture on Purple Wave even.
And what piece of equipment was that?
That was the shot blaster, the BP 15. That also has a Blast Pro 954 vacuum with it, a HEPA vacuum with it.
Okay, and did you know at that time, and when was this? What month, year was this that you
It
found
was-
this? And
It was 2022, and I want to say around probably October. It was the point that they were able to get a search warrant the first time. And I don't know if that was October, if it was early November.
Okay, so around late October, early November is when you see this on Purple Wave, and you know it's your piece of equipment based on the serial number.
Correct.
And where there's pictures of the serial number,
Yes. Yes.
and
And I
at the time that the defendant was employed, or shortly after he was still employed with you, which you said was in November, December of 2021. So basically a year before this, did you know where he lived?
Yes.
And where is that?
He had lived at a house on Flynn Street, which is South Rock Road and Pawnee-ish. When he asked to borrow the box truck, he said he was moving to a place down south. And we didn't know, we thought he was moving to that location. We didn't know he was keeping both houses. But because of him clocking in, I knew he had taken stuff down to that south. He had clocked in to go down south, and there would have been no other reason for him to do that.
Okay, maybe let's back up. So we'll come back to that. You see the piece of equipment on Purple Wave, you match a serial number to the photographs that they've posted, and you contact law enforcement to tell them that you found this Blast Pro piece of equipment.
Yes.
Okay. Now, as we noted, this is approximately 1 year after he no longer worked for your company, correct?
Correct.
Okay. And had you asked him to, or told him or allowed him to take any of this property, to take any of these pieces of equipment besides borrowing the box truck temporarily?
No.
And had you asked him to repair any of them or store any of them on behalf of your company?
No. Not after that point of the truck, December 1st of 2021. No. And before that, he was not, no, repairing any of it. No. And not storing it either.
Okay. Now, you just mentioned clocking in and clocking out. I guess maybe explain to me what you mean by that, and does that have something to do with when he was still employed?
Yes, we used a service, and it was an app called Clock Shark, and we started using that in 2019. And it's just an app that employees can clock into a job when they get to the site, and they clock out when they leave. It keeps track of it. It does GPS while you're clocked in to that job.
Okay. So what significance does the clocking in, clocking out have to do with the property missing?
Because we live close to where we were storing it. Where we were storing it's a kind of a unique place. It's at 13th and Andover Road, but it's in between the building and 35, Interstate 35 that goes over it. So it's on the north side of that building, and it's fenced, and we kept it locked. But because it was outside and against the building, I went down there weekly and took pictures of everything there, just to I don't know, I just did it. And I did it in the warehouse too, when we were at the warehouse in Bel Air. And so I can compare the pictures that I took, but also he told, we had another employee at the time that he actually gave a piece of the equipment back to, and I don't know the date of that, but it was mid-November to late November. I didn't want to think that he took all of that equipment, but he took all that equipment because I've seen it up for sale online. And I know that one of the posts shows that it was posted January 1st of 2022 that he started trying to sell our equipment. I didn't catch it at that time because I wasn't familiar with all these online auctions that there are and places there are to sell equipment. But it was pretty clear when he went and returned the box truck, it was pretty clear that what was going on. I don't know how long he had been doing it. I suspect it was over several days. It wasn't a one-time thing because it was a lot of equipment.
Okay, so you take weekly pictures of this lot storage that's fenced, and how many people had access to that area?
Probably 3 or 4 people. Our lock had a combination on it. It wasn't a key lock. It was just a combo. And so there was a handful of people that probably had that combination.
Okay,
or
so
that even knew that it was there, because you don't really see it from the street, and there's only one way to access it is from 13th Street. It's fenced. So he knows about it because he helped us deliver the product and stuff there to begin with, over like April, May, and June of 2021 is when it was delivered there.
And when you say product, you mean the equipment and maybe other building materials?
We were evicted from our office in Bel Air that we had been at for 20 years. And that was part of my story of what led us to where we're at. We'd been in I think 12,000 square foot warehouse that we had pallet racked, 3 high, and we'd been there 20 years. And we had like 10 days to move out once we were evicted. And obviously it took us longer than that, but there was a shortage of storage trailers, which was our plan. We were going to get storage trailers and park them there. There's a shortage in Wichita. We could not get storage trailers. At the time we were fighting the court case down in Oklahoma that took more of my time. And so I know Mark knew there was opportunity to do this.
And you were changing locations. You said April through June. Was that 2020 or 2021?
2021.
Okay. And did you end up having, after you found this piece of equipment, did you actually get that piece of equipment back? This blast?
No, we still have not. We have not gotten any of our equipment back. other than from this latest search warrant that was the second one.
Okay, now, do you end up having contact with law enforcement a subsequent time after you report this Purple Wave Blast Pro piece of equipment? Then what happens?
They got a judge to sign off on the search warrant for the one house where the Blast Pro was in the picture at his house. They did a search warrant there, and I don't know anything other than them calling me and saying that he said he doesn't have the equipment anymore, that he sold it all because we owed him money. Because
and did you owe him money?
I do not believe I owed him money for what he said. He said that it was for storage, that we were supposed to be paying him for storage. That's what the agreement was, but I don't have an agreement. There was never a verbal agreement for him. We had just moved it all to storage at 13th and Andover Road. I've never received an invoice from him. I don't know a dollar amount that we supposedly owe him. And in the time that it was taken to the time we knew for sure that some equipment had been sold, he had told the police officer that he sold it all. And so I'm like, okay, what are we supposed to do now? Because nobody's doing anything, and he has stolen everything that we used to, try and create some revenue for our business. And I mean, he just took it all. And
The state's next question to the witness is what, Ms. Norris?
And so the next time you have contact with law enforcement, are they actually doing another search warrant?
No, well, no, a little more time went by and we still nothing. And I was trying to figure out how we could get a search warrant for his house down south. That's what the struggle was. Because he had everything covered up in tarps. He had a semi-trailer parked out front there. We couldn't get the search warrant, but then on Facebook Marketplace, I saw his wife had put my husband's motorcycle up for sale. And so I contacted the police department again saying, okay, he obviously still has a motorcycle because his wife's trying to sell it.
And what kind of motorcycle was it?
A Yamaha, like a dirt bike motorcycle.
Okay, and so you saw something on Facebook Marketplace, and you know what defendant's wife's name is?
Michaela, I think. I'm not positive what her name is, but I recognized the motorcycle. I was still doing periodic searches for our stuff.
Okay,
I mean,
so you didn't necessarily look up her specifically.
no.
You just saw there was a motorcycle and you looked at it knowing that you had a motorcycle missing.
Right.
Okay. And you know, what color is it? You know, what kind it is?
It was a dirt bike that, I don't know, it was kind of a little bit unique, and I had pictures of ours from, it had been in the warehouse, and I knew what it looked like and I could compare it that way.
Okay.
And with it being his wife being the seller, and I knew what the VIN number was for it. And so it was pretty clear that it was our bike or my husband's
And
bike.
were you able to see the VIN in the photos on Facebook Marketplace, or was that
No.
something that they discovered later?
I don't know when they discovered it. I know I had it. I mean, I had given it to the police prior to.
Okay. That I guess my question wasn't clear. I want to know if you can see the VIN when you're looking at the pictures on Facebook Marketplace.
I don't think so. I don't think so.
You recognize it just because it's sort of unique and you've seen it before and it's your husband's, and so you call it into law enforcement.
Yes.
Okay. And then after that, do you end up needing to, then you end up getting the motorcycle identified and is it your motorcycle?
So I had pictures of the motorcycle that I sent to the police department. And it took several times because I think the detective at the time was on leave. So it was several days. But then they were able to get another search warrant or do a search on that with the information that I'd given them about our stuff and the history of knowing that we were trying to get another search warrant and what had happened throughout the year before.
But did you get the motorcycle back? I mean, did they recover it from someone?
Yes.
Okay. And so the motorcycle that you had seen on Facebook Marketplace was in fact your husband's motorcycle?
Yes.
A white and blue 2000 Yamaha 450 motorcycle?
Yeah, it was a 2003.
I'm sorry, if I didn't say 2003, that's what I meant.
Okay, I'm sorry. I heard just 2000. So.
And did you end up looking at more property besides the motorcycle thereafter that was yours?
Yes.
And was that in conjunction with law enforcement executing another search warrant?
I don't know what happened on their side. I just know we got a call to come and take a look because there was a lot more stuff that was there this time that wasn't there the last time they searched the house.
Okay, so where did you go to look at property with law enforcement?
To his house on Flynn, which is Rock and Pawnee.
Okay, so you go there and you look at property. Are you able to identify property as being yours? And if so, how did you go about doing that?
I brought my iPad with me and I had pictures of our property on there that we were able to try and identify. And I know looking through the pictures now, I know there's stuff that is still there at his house that is ours. Yeah, and I mean, there was stuff with our name on it, like Bishop. There is, I mean, you saw I assume everybody has seen the list of everything that was recovered.
That's no one except for probably me and law enforcement has seen the list. The court doesn't necessarily get like full police reports, but we're talking countless items.
It was a list of stuff. It wasn't our equipment though. But it was a lot of stuff, yes.
Like miscellaneous stuff like rolls of rubber adhesive, saw blade, sledgehammer.
He had some of our tile saws. There was a folding white table. There was a job box that we had, a gray job box, like a job site job box that was in his garage. Some tool, like tool boxes. There was a cooler that was an OtterBox cooler that we found. I mean, there was a lot there.
Okay, so miscellaneous tools and a lot of other things, but none of your really expensive, larger, big pieces of equipment.
Correct.
Okay, so like the Blast Pro machine that you still haven't found that was sold on Purple Wave, which I think the defendant told law enforcement that he did actually do that. I think that's what you said earlier, but about how much is that piece of equipment when it was new?
It's two pieces of equipment together, but they work with each other. And I want to say we paid around $60,000 for them in 2016.
Okay.
for
And-
a project. But it did not sell on Purple Wave. Purple Wave pulled it before the auction. But then by the time the search warrant was served to Mark in Wichita, he said he had sold it, and I was told that it was sold back to the company who sold it to us, Blast Pro. And we're like, okay. I think he said that he sold it for $22,000, and I still don't know how we're supposed to get that back or how that works. I know the police department contacted Blast Pro, and he would have to speak to what went on there, but we still don't have our equipment. But I know it did not go in the auction. It was pulled before the auction.
Okay. And, but out of all the items that were that you did find, and then these other items that are still missing, about how much are these items, you know, or were they worth at the time that they were taken?
I bet I can get to $500,000 worth of stuff easily. That's how much stuff he has taken.
Okay. And the stuff that was located, are the kind of miscellaneous tools and the cooler and all that kind of stuff. Do you recall about how much of that recovered property was? Was that over $10,000 worth of items?
That came up to about $30,000 worth of stuff.
Okay.
I don't mean to cut off here or anything or inject, but do I get to question the witness here today at this time as well, Your Honor?
Not at this time, but eventually you will, Mr. Carter.
Okay.
You'll just wait your turn.
Okay. Sorry.
Any further questions for this witness?
No, not for me.
I was asking the prosecutor.
Oh, from the prosecutor. Okay.
And no, Your Honor, I don't think I do at this time. Thank you, Ms. Bishop.
All right. Now, Mr. Carter, if you have questions for.
Don't go anywhere,
Yes,
Ms.
then
Bishop.
Okay.
Stay with
remember,
us.
you ask the question, Mr. Carter, she provides an answer, okay?
Okay. Sounds good. Thank you. Yes. Okay, Kim, let me ask you, you stated that you stated here today that you reported the box truck stolen on December 1st of 2021, or the box truck was returned December 1st of 2021, and then you reported it the next day or the day after that. Is that correct?
No, that's your misunderstanding. We recovered the box truck on December 1st. That's when we were able to get it back. And it was that very next day, because it was like 2:00 in the morning, I want to say. And I think it was the next day is when we filed the report of the stolen equipment, not of the box truck, but that you had the box truck and would not return it. But then we recovered the box truck. There's damage to it. There was.
Okay, that's not my question. I mean, you answered my question, but that's all I needed.
Okay.
So you reported the equipment the next day after the box truck. So what day did you initially report the box truck stolen?
We never reported the box truck stolen. We reported that you had not returned it because we let you borrow it to move.
What day did
But
you
then
report?
you would not return it.
What day did you make that report for the box truck?
We did not make a report for the box truck. When we got the box truck back in our possession, that's when we filed the police report, because you would not return the box truck. And we knew the equipment was gone at that point.
Okay, see, I'm trying to understand this here. So you reported the box truck as not being returned, but you didn't report the box truck at all.
That was part of our report. That was part of the actions that you had done up until that point in the last the 3 to 4 weeks prior to that. Because
Okay.
you kept that, you borrowed it, but you didn't return it.
Okay. So well, let's say December 2nd, you reported the equipment gone. Is that what you're saying?
Yeah, yes.
Okay.
That was when the police report was filed.
And what equipment was on that report?
The equipment of the shot blaster, the national carpet flooring scraper, all of the stuff that we had serial numbers for and we knew was gone.
Okay. Now, speaking of serial numbers, the serial number for the Blast Pro that was listed on the search warrant, was that accurate?
I did not see the search warrant.
With the one that you gave the police?
I didn't give them a search warrant.
You didn't mind, so you gave the serial number that you gave them?
What is your question?
The serial number that you reported for the Blast Pro machine to the police, that was an accurate serial number for the machine that you reported stolen, correct?
I don't know what you're asking, since I have the documentation of what the serial numbers were for the equipment. I assume that they typed it in right, but I don't know I didn't see the search warrant.
Okay, I'll say that for a later time. Okay, now the weeks leading up before the December 1st or 2nd report, you stated that I had contacted another employee, or another employer had contacted me and received another piece of equipment from me that I was storing. Is that correct?
No, that's not correct. It was a piece of equipment that he went to go pick up at 13th Street and it wasn't there. He asked you if you had it and you had it, but there was no reason for you to have it. But he made a time and schedule to get it back from you at that point.
Do you recall if I was working at all at any time during that time frame that I was contacted by the other employee? Was I still an employee of Total at that time?
I think at the time we thought you were, but I didn't. You never like officially quit. It was just you stole all the equipment, and then it was obvious that what had happened.
Okay, so the weeks leading up before the December 2nd report and the return of the box truck, you said that I was in Clock Shark, correct?
You did clock in.
And I was, the GPS showed me down at the other place down south. Is that correct?
Yes.
Okay. Would it be fair to say that I was clocked in for what reason? What reason was I clocked in for?
I don't know why you're asking that. You were
Why would I have been clocked?
You did different jobs. You went to different places to do different jobs. You clocked into those jobs. You clocked out of those jobs.
Okay,
so
there's that I was an employee, correct?
Okay, wait, you two, you can't talk over one another.
Sorry.
I'm trying to make an electronic recording of these proceedings, and there's no way this could be accurately transcribed if you're talking at the same time.
I'm sorry, Your Honor.
So, Ms. Bishop, let me instruct you, just narrowly answer the question that's being put to you. And
Okay.
Mr. Carter, allow her to finish answering the question before you start talking again, okay?
Yes, sir. Yes, sir.
Ask your next question, Mr. Carter.
Yes. What reason was I clocked in to show my GPS location down at my south house?
There would have been no reason for that.
Okay. Were you aware of any conversations that I had with your husband about work or anything of that nature?
Not that you had around me that I would know. And I do want to add to the part on the GPS. I didn't check GPS on our employees every time I did payroll. I just would normally do the hours. I only checked the GPS because of the equipment missing. I was able to go back and see that he had clocked in and driven down south and was clocked in down there for several hours. That's not normally something I would check or should have to check.
Okay.
I don't know if that makes sense.
My next question is, did you ever tell detectives that I had stored anything for you or your husband?
No, I told,
Okay.
we were storing the product at 13th Street, Mark. We were never storing it at your house.
I'm just asking you. Simple question, simple answer.
No, the answer is no.
Thank you. So when did you report the dirt bike stolen? Was that reported on the December 2nd report in 2021?
The report was a list of product and equipment and tools. I still don't know to this day. I can only give what we know for sure is gone, not everything that I'm sure is gone.
Didn't you go out there every week and take pictures as you just testified to?
I did go out there and take pictures every week.
And compare?
Mark, I didn't compare them at the time. I can only do that now that I know everything that was gone.
Okay. So when did you report the dirt bike as being stolen?
It was part of the unknown of what was gone. We knew the dirt bike was gone. That was obvious. That was from the initial report. I don't have a copy of that. I don't know what all was on there. I know that for sure the equipment was on there because that was our main priority of getting it back. I don't know what all was on there from that.
What date did you notify law enforcement in Andover, Kansas that the dirt bike had been stolen and you see it online? When did you know the dirt bike was stolen? And when did you make the report for it being stolen?
December. We've only filed one police report of 2021.
So the December 2021 report should state in there the dirt bike, correct?
I don't know if it specifically says the dirt bike. I just know it was unknown what all was gone at that point when the police report was filed.
But you'd given them a list though at that time, right?
I think I don't remember, and I don't have a copy of the police report. I don't know if it was a list that was made at the time that we were sitting at the police department or if it was something that was sent later. I don't know.
Okay. Now, if I had stolen the equipment, supposedly as you claim, during the time frames just weeks before the December 2nd report, when I was borrowing the box truck to clock into work for no reason whatsoever to work, and the other employee asked me for the equipment back, if I had stolen it, why would I give that equipment back to the other employee, do you think?
I'm not sure what your
Calls
question
for
is.
speculation.
Objection sustained. Next question, Mr. Carter.
Sorry about that. Well, when you came to my house to identify items that were supposedly stolen from you back in 2021, actually back in, April 5th of 2022 or 23, I'm talking about the search warrant where you came to my house on the 23rd of April of this year, April 5th. Did you come over, and what were you instructed to do by the law enforcement officers there on the scene that day?
To come and identify what property was ours. And I know pictures would help of what your garage looked like, of why they could not go in there and identify specific things. because there's just so much stuff.
Because it wasn't in
No.
the, there wasn't an item specifically listed in the report that they were trying to identify, correct?
There had been several email exchanges of updating property and stuff that we were missing from that initial.
From which day? From then, from April 5th, from till now, or I'm talking about prior to that.
It was.
All I need to know is, what did the officers instruct you to do the day that you came to my house on April 5th of 2023? What were your instructions?
That they had recovered, they called and said they'd recovered the dirt bike, and that there was some other property that matched the pictures that I had given to them of our equipment and tools and stuff that was missing.
There was pictures of it that they
There was.
Okay.
It wasn't like pictures. It was a piece of paper, like a 11 by 14 piece of a picture that had a bunch of pictures on them. It was like a screenshot from your computer of pictures from the warehouse of our property.
Okay. Now, while you were there, did you ever identify anything that wasn't yours that originally that you may have told Tim to have them listed either way because it needed to be put into evidence so somebody else can claim it? Did you ever make that statement that day?
I don't recall making that statement.
Okay.
No.
That's fair. Did you, when you were at the house that day, did you ever point out any item that you knew not to be your item prior to that day, but still claimed to be yours at that moment, just to take it?
No. In fact,
Okay.
we were very careful about that.
Did you have pictures of every item that you took that day, prior to that day that you took the items from my garage?
Yes.
Every single item?
I would think so. That was part of why I had the iPad and the pictures with us.
Okay. Back to whenever before the 3 weeks or so before the report was made originally in 2021, December 2021, were you aware of where Tim was working at the time, what job he was at, and what project he was working on at that time frame? Do you know?
I think that he was between a couple of different jobs at the time.
Do you know of any other jobs where I would have been working at during that time frame or projects I was working on for you?
I know you were helping Jimmy do the Millicare, the carpet cleaning side of it is what you were mainly doing. And I know you helped him some. I know you weren't available a lot when he did need you to help him there towards the end for sure.
Why wasn't I able to help him?
What?
Why wasn't I able to help him? Do you know?
It was probably you had other things going on that I don't know.
Like clocking in for no reason? Is that what you're saying?
Did you say like clocking in for no reason?
Yes.
No, I didn't mean to say that. It was there was no reason for you to be clocked in at your house down south.
Okay.
You were helping Jimmy do the carpet cleaning side, and that you were scheduling your hours with him.
So do you not know of me helping Tim out in the basement in Valley Center doing grinding and polishing there?
I'm sure you probably did help him in Valley Center.
Okay, that's all I have for that. The day So I know you've stated that you've only made the one report to detectives for all of the equipment and whatnot, and it was on or about December 2nd of 2021. And the serial numbers were all given to them at that time for all the equipment that you had listed, and all the photos were pretty much submitted at that time as well, correct?
There was that submitted at that time, and there was also stuff submitted between that and now. I mean, as we were able to gather the information and put it into a format, there were emails that were sent to them.
All right. Let me ask you this, Kim, did you ever report to the federal government on a contract job, wages that you had paid me that were inaccurate in any way?
Mark, your time for McConnell Air Force Base was reported to the contractor. And if you've got a problem with that, like you threatened to file a labor department complaint, file the complaint with the labor department.
Get into a bickering match over some sort of wage claim.
I'm not trying to. I'm just straight asking a question. I'm just asking for a simple answer. It's very relevant, and I do have evidence to submit in support of this to show for character purposes, Your Honor.
Yeah, I'm not sure her character is legitimately at issue here. All right. Have you completed that line of questioning, Mr. Carter?
No, I'm just, it's got about 2 to 3 small parts, just simple answers, and that's all.
That has to do with your wages?
For what they were trying to claim, it's for a reason they're trying to claim as me stealing stuff from them. It's kind of their excuse as to saying why I stole something from them when I haven't stolen anything at all. That's why. They're trying to use another point of saying that I have a reason to go and steal. They owe me money is what it originally came down to at the beginning of her testimony. Then I owed her money, and that's why I stole something.
Because that's what you told the police officer.
I never told the police officer anything like that.
All right, perhaps we should move forward by Mr. Carter, you asking your next question.
Thank you.
Will determine whether I will allow.
Thank you. My question was, did you ever report wages to the federal government regarding the McConnell Air Force Base job for Davis-Bacon pay hours that you claim were paid to me by you and your company?
Those hours were reported weekly to the contractor in 2020 for that project.
Okay, why don't you stop there?
Okay.
Any further question along those lines, Mr. Carter?
Yes, it's to deal with the temporary agency that I was working for at the time. I was subcontracting through a temporary.
I'm not wanting to hear your side of it. When I'm here, do you have another question for her?
Yes. Yes.
Ask it.
Okay. While I was working before I became a total installation permanent employee, and I was working for the temp agency over on West Street, DES Solutions, did you report the same wages to DES Solutions as you did to the federal government for the contract paperwork on McConnell Air Force Base?
Yes, those hours were reported. And at the time that you were a subcontractor through a temporary agency is how it was reported.
Okay, that's all I need. Thank you. I have no more questions about that now, Your Honor. That'll be coming into play later. Thank you. I think there was one more. Hang on, let me read through my notes just briefly here, okay? And I might have one question later after this, and that's it. And if not, I'll be done. Okay, so the dirt bike, what, you said you were looking through and you noticed the dirt bike. Where did you notice the dirt bike for sale at?
On Facebook Marketplace.
Okay, and you still, can you describe the colors of the motorcycle?
Blue and white and yellow.
Yellow?
There
Okay,
was like a yellow part on the stickers or something. I compared it to a picture that I had from the warehouse, Mark.
I'm just asking simple questions, that's all. Simple answers. Did you ever report to the police that the box truck had been located after the report was made on December 2nd of 2021?
Objection, Your Honor, asked and answered several times.
Not this portion, no, it's not.
Objection sustained.
Okay. I'm done with this witness. We can go ahead and call the next one if you want, Your Honor.
Anything further for this witness at this time, Ms. Norris?
No, Your Honor, thank you.
Do you intend to present further evidence at the preliminary hearing, Ms. Norris?
Your Honor, briefly, I will ask that we call Tim Bishop.
Will he be your last witness?
I believe so, Your Honor.
Okay. So then I need to inquire, Mr. Carter, do you intend to present evidence at this preliminary hearing stage of the case?
Yes, I do, Your Honor.
All right, counsel, we're going to have to bifurcate this proceeding. We're already out of time. This was a single count property crime felony, and I set it for an hour. I have to move on to other matters, and it doesn't appear we're anywhere near a conclusion. So I'm going to have to go ahead and reschedule, but unless my assistant tells me otherwise, I can pick this up at 3:30 tomorrow.
Your Honor, I'm not sure I'm available, but could we bring in all the other witnesses so they can be, we could talk to them about their calendars as well?
Yes?
Thank you.
And Your Honor, at this time, I would like to go ahead and make the motion for the return of, at the bare minimum, my welder back, because they didn't have any, they have no serial number, they have no evidence of anything. It was not listed in the search warrant specifically, and it is not their equipment. I have photos, I've submitted documentation to the detectives that proves that I've had that thing for a long time. And I would like, I'm missing out on money right now because I can't weld.
Sorry.
And Your Honor, I think I'm available. I'm having a hard time getting into both my, I could see obviously my book calendar, but I'm having a hard time getting into my computerized calendar for whatever reason. But I do believe I am available in the afternoon of July 28th.
I was looking at late morning, 10:30 to noon.
Oh, I'm sorry. Yes, Your Honor, that should be fine.
All right, I will reschedule then the Mark Carter matter to resume the preliminary hearing, having completed one witness's testimony for 10:30 a.m. on Friday, July the 28th. That again will be by Zoom. We'll use the same Zoom numbers as we did today to reconvene the hearing. Again, that's Friday, July 28th at 10:30. Mr. Carter, did you file any type of written motion regarding the return of property?
No, I have not. I didn't know I needed to file it in writing, Your Honor. They
Did
won't
you
let me
hear
electronically
his
file it.
request, Ms. Norris? He's got it. Apparently they confiscated a welder that he says isn't involved as stolen property or evidence in this case.
Yes, Your Honor. He actually has, he brought that up at the last setting, according to file notes. That was back June 5th. I don't have any information that, other than his request made on the record, that is his, and that it should be returned. It's in evidence with law enforcement, as far as I understand. And like I said, other than him, saying kind of the same thing. I don't have any information from law enforcement or any documentation that leads me to believe that it was wrongly taken as part of the search warrant. Sometimes things like that, could happen, but I
was never
don't.
listed on the
I
warrant.
don't have any information that is the case. And I do believe he's talked to Lieutenant Scheinert more than once. And I think he's probably been told that it's in evidence and it will stay there until, the case is complete without some other, orders from the court.
I'll take this under advisement. I may rule on it on July 28th, but frankly, there's no welder charged to stolen property in this case. And I would expect, Ms. Norris, that you'll check with the victims in this case to see if a welder was one of the items that they had that came up missing. And if the department doesn't have any reason to believe that this has been stolen either from these alleged victims or some other alleged victim, the property really ought to be returned to Mr. Carter.
Well, and Your Honor, I did not list every single piece of property that they
I
found.
understand that. And
Miscellaneous
it's
tools
probably-
covers a lot of things, but
Miscellaneous
if the
concrete.
court wants me to list every single item, this information will go from, 2 pages to probably like 3 or 4.
All we're discussing is the welder, and I don't see it listed as a specific item. It very well may be involved in this case. All I'm simply expressing is I would ask you to look into it, and if the welder is not needed as evidence in this case, it ought to be released.
And Your Honor, I like I said, I understand his position, but it's been my understanding after speaking with law enforcement, et cetera, that it was appropriately in their care and custody. But I will have further discussions with them and find out more information.
Thank you. I appreciate your efforts in that regard, and we'll address it again, most likely on July the 28th.
That'd be my guess. Yes, Your Honor. July 28th, 10:30.
10:30 a.m. Again, by Zoom.
And Your Honor, could I have all witnesses be ordered to return at that time for purposes of not reissuing subpoenas?
The court so orders, Ms. Norris. Everyone that's been subpoenaed to testify today is also subpoenaed and ordered by the court to be available by Zoom Friday, July 28th at 10:30 unless released. The Carter matter will currently be in recess. You may end this meeting for all at this time, Andy. This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Mark Anthony Carter. It's case number 2023 CR 194. Mr. Carter appears on the meeting, again, representing himself. Amber Norris appears for the state of Kansas. Numerous witnesses that apparently have been summoned by the state are also present on this meeting. This matter comes before the court at this time for continuation of the preliminary hearing that was initiated on July 5 of 2023. At that time, Kim Bishop completed her testimony, but due to time constraints, the prelim was bifurcated and continued for further hearing today at 10:30. I trust that the state's again ready to proceed, Ms. Norris.
Yes, Your Honor.
You may call your next witness.
State calls Lieutenant Michael Scheinert.
Right. I think I'm going to go ahead and sequester the other witnesses. So if we could have the other witnesses besides Mr. Scheinert placed in a waiting room until it's time for them to testify. All right, Mr. Scheinert, if you'd raise your right hand, I'll administer an oath. You do solemnly swear that the testimony you're about to give in the matter now on hearing shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, Your Honor.
You may question the witness, Ms. Norris.
Thank you, Your Honor. Please state your name and occupation for the record.
Michael Scheinert, and I'm a police officer with the Andover Police Department.
And how long have you been in law enforcement?
A little over 10 years.
And how long with Andover?
Same.
And how long in your current position?
About 2 years.
And are you familiar with the defendant, Mark Carter?
Yes.
And can you explain briefly why you're familiar with Mr. Carter? And do you see him on your screen today?
Yes, I worked a burglary / theft case involving Mr. Carter, and he is kind of an orange background, white walls, white male with a beard, short hair.
Okay, and that's the same Mark Carter that you have dealt with regarding this burglary theft case that you just referenced.
Yes.
Your Honor, would ask that the record reflect that the witness has identified the defendant, Mark Carter.
The record so reflects.
Thank you, Your Honor. This case started a while ago, is that correct?
Yes.
And just briefly, it started when, and then when did you really start making, I guess, good progress with the case?
It started, I think, in November of 2021. And first came in, I think, as an employee that stole a work truck. And then the victims in the case kind of lost contact with them for almost a year. I think they were going through a civil case is what they told me is why they weren't answering calls or anything. And then they noticed that some property that they had in a warehouse that was being stored somewhere had all gone missing. And they believe that Mark Carter was the person that took that stuff. And they found one of the items that went missing on Purple Wave being sold by Mark Carter.
Okay, and so is that, what did you do with that information?
I contacted an employee of Purple Wave, and asked him about the item that was being sold and verified the serial numbers, and verified that serial number did match the one that they were reporting stolen. And then you want me to keep going?
And what was that piece of equipment?
It was a Blast Pro large concrete piece of equipment.
And like Blast Pro shock blaster machine.
Yes.
And were you able to, so you talked to Purple Wave, were you able to recover that from them, or how did that end up playing out? And were you able to get any documentation? I mean, how did you know that it was Mr. Carter?
So there were photographs of the item. And you could see the house and the yard in the background of the photos of the item. And we drove by the house and verified that those pictures were taken in the driveway at that residence.
And what residence?
Mark Carter's residence.
Okay.
And then talking to the Purple Wave employee, he sent me like the contract for selling the piece of equipment, and it had Mark Carter's name on it. And I had a discussion with him. If I remember right, it was supposed to be sold that day or the day after, go to auction. And he told me that it wasn't actually going to auction because they felt like Mark Carter, or the person that was selling the piece of equipment, was shady. So they kind of canceled the entire transaction.
Okay, so it didn't actually get sold through Purple Wave, but you confirmed so the contract, did it have phone number, address, name, those sorts of things where you could confirm that the Mark Carter that's in the paperwork is the same as the Mark Carter that you've identified here today?
Yes.
And did you talk to Mark Carter regarding said piece of equipment?
So the first thing we did was apply for a search warrant, believing that the item was still there because the pictures were taken fairly recently.
Still there where?
At Mark Carter's residence.
Okay, and is that on South Flynn?
Yes.
Okay,
So we applied for the search warrant and went to the house. I don't believe Mark Carter was home. And he had a Ring doorbell, and we rung the doorbell and talked to him through the ring. And he asked that we wait and not bust through his door or anything like that. So we did. We waited for him to come home for wherever he was at. And that's when I had a discussion with Mark Carter about the equipment.
okay, and so did he tell you that he did have the equipment and that he did sell it?
Yes,
So you were not able to recover that Blast Pro piece of equipment on behalf of the victims?
no,
Okay. And he didn't sell it through Purple Wave. Where did he sell it, if you know?
he told me that he sold it directly back to the Blast Pro company in Oklahoma. And
Okay.
then I came back and called Blast Pro and verified that they did have that equipment. It was sold by Mark Carter to them. But they wouldn't give it back or anything, which is
Okay.
understandable because they spent a lot of money buying it from him.
Okay. And so the search warrant obviously did not yield that piece of equipment. Did you do any additional search warrants in this case?
Yes,
And when and where after this particular one?
so after that initial search warrant, I had a discussion with Mark. I don't know, is now a good time to go into that?
Well, when's the next time you do a search warrant?
It was on April 5th of 2022,
April 5th of 2022 or 2023?
2023.
Okay, because the one that you just talked about where you went to his house to look for that Blast Pro machine, when was that one?
That was December 8th of 2022.
Okay. Okay, so let's talk about why did you do another search warrant in April of 2023?
I was talking with Miss Bishop, and she stated that a dirt bike that was stolen during the same time that they believe Mark Carter had stolen came up for sale on Facebook. And it was being sold by his wife, Kayla Carter.
Okay, so she sees something on Facebook Marketplace and she identifies this motorcycle as being something else that is missing.
Yes,
And so what did you do with that information?
I contacted Kayla on Facebook, pretending to be someone else, and set up kind of a transaction to go purchase the motorcycle. In the meantime, writing up a second search warrant. And when that got approved, we went over to the house and was able to recover the motorcycle.
Okay, so you basically set up a fake buy
Yes,
of the motorcycle, which
Right.
Were you able to confirm prior to the buy that it was in fact the victim's stolen motorcycle?
yes.
And how were you able to confirm that?
There was a piece that was missing on it, that the victim in the case had to weld to fix. And in the picture, it was clearly, the piece that he was talking about was clearly on there. And he was able to describe the colors and everything like that. And actually, when we got to the house, first thing we did was verify the serial number or the VIN number on the motorcycle, and it matched the VIN number that the victims gave to us.
Okay. So you said go to the house. Where are you going to do this motorcycle transaction?
On South Flynn,
Okay, so same address that you had been at before.
correct.
And had something changed between the December 2022 search warrant and the April 2023 search warrant?
As in, I think the property was still missing. We still haven't recovered anything.
Right, but you had done a search warrant in December. I mean, obviously you were looking for the Blast Pro, but was there another property where that the defendant owned?
Yes,
like this, say, like, had you run across this motorcycle in December of 2022 when you
No.
were at Mark Carter's?
It was not there.
Okay. And, but like, so what had changed between December and April?
We knew about a property that Mr. Carter had in Sedgwick County, I think close to Iola somewhere. And we were never able to get a search warrant for there. There's just nothing that ever gave us enough probable cause to go over there and search that property. So, and from what the victims was telling me, he may have been evicted from that property. So he may have been moving stuff back to Flynn, and maybe that's why the motorcycle showed up.
And is, you said Iola, is it Viola or Iola?
Viola.
Viola. Okay. Viola in Sedgwick County. Okay. So see the motorcycle, go to basically confirm / make the buy. And then what did you do once you confirmed that the motorcycle was in fact a stolen one and at the residence on Flynn?
We seized the motorcycle and then executed the search warrant on the Flynn address for the rest of the property.
And what was the rest of the property?
The property that was taken out of the warehouse storage area that the victims had reported still missing.
And how did you word that?
It was the exact pieces of machinery that we knew about, and then we put their business was like concrete work, flooring work. So we worded as concrete tools and equipment or something similar.
Okay, because you're not necessarily, as a law enforcement officer, familiar with how you do floors and concrete necessarily work.
Correct. I had no idea what any of this equipment was.
Okay, or what kind of tools or anything like that.
Right.
Okay, so your search warrant was, let's, I don't want to say completely vague, but maybe a little more vague when it came to the concrete tools and equipment.
I would agree with that.
Okay, so you executed that search warrant on the Flynn address,
Yes.
and I guess kind of just basically walk me through how you did that. Who was there and what was your process and procedure, if you could?
So the residence, I believe there's pictures of what it looked like. It was, I mean, it's pretty trashed, full of stuff. And again, I didn't really know exactly what I was looking for as far as concrete tools. So I had the victims meet me at the residence to help me look at stuff. And I also had the defendant's wife with me.
Okay, so the defendant wasn't present, but Kayla Carter was.
Correct.
Okay, so are we talking, you said it's kind of trashed. Are we talking like hoarders
Yes.
trashed or, okay, and describe the property. I mean, you know, is it a house with a garage or outbuildings or just a yard full of stuff? Kind of explain, give the lay of the land for the court.
It's a house with a, I believe, 2-car garage.
Attached, unattached?
Attached.
Okay.
The garage was completely piled almost to the ceiling and all 4 walls of stuff. The inside of the residence, you can't even walk on the floors. There's so much stuff. The backyard, can't even see the ground. There was so much stuff on the ground. There's stuff everywhere.
Okay. Okay. So a lot of things to go through.
Correct.
All right. So you've got the defendant's wife, Kayla, and you've got Kim and Tim Bishop, the victims.
Yes.
Okay. Now, what's the process regarding the property? I mean, what are you doing and how are you validating and verifying these sorts of things?
So it was myself, Detective Snedeker, and Detective Sign were all present, and we were searching through the stuff with Kim and Tim kind of looking over my shoulder and Kayla on the other side looking over my shoulder, and they would identify something as theirs, and then I would tell them they had to prove it somehow. And first time I ever had a victim do this, but they had pictures of everything, their entire warehouse. So they were able to pull it up on the pictures, and still, if Kayla said that that's not theirs, that's Mark's or mine, there's a lot of things that Kim and Tim would say that was theirs. Kayla would say it wasn't, and I told them we couldn't take it.
Okay, and if Kim and Tim said it was theirs and they could confirm by photograph, and then was and Kayla said yes or no, if they could confirm by photograph, what did you do?
I seized the item.
Okay, and on most of the items that you seized, which I know you did like a whole separate report, I think, that lists out a bunch of the items that you took. Of those items, do you recall if any of the ones that you took that Kim and Tim showed either photographs or identifying marks, or could identify the property in some capacity? And then did you actually ask Kayla, is that yours or Mark's? And if she responded no,
Yes.
yes. I mean, any of the items that you took, had she responded yes, those are ours, or were they all no's, they were not theirs?
There's a couple things, and that's the reason why I stored them in evidence, because she would say yes, those are mine or Mark's, but then they would have a picture of it in their warehouse.
Okay. And were there some things though that she agreed no, they absolutely weren't hers or Mark's?
Correct.
Okay, so a little bit of each, but she was with you the whole time during this process.
Yes.
Okay, now, and if you just quickly want to list out the items that you found that you did recover as stolen. And this was based on Kim showing you pictures, and then also either Kim or Tim giving you physical marking descriptions, or how did this, I guess,
So-
a little more detail about how you guys figured this out.
There were some items, like some of the hand tools. I asked Tim before we even looked at any of this stuff, how would I know that that's yours? And he told me, I can't remember the colors without looking at the report, but there'd be certain colors of paint on the tools. And sure enough, when we were going through, we'd find the hand tools and they would have the paint colors he described that were on them. There were also some items that had their company tag on them, Total Installations. And the tag was on there saying that it belonged to them, and had Tim's phone number, call this number if found. But like I said, most of the things we took had pictures. They had pictures of the items.
Okay, from their warehouse.
Yes.
Okay, and so I guess if you could go through the list and just name a few items, and that's that would probably be helpful for the court.
Okay. Is it okay to read it from my narrative?
Sure. I don't expect you to remember all of
Okay.
these items, especially after, since April.
Okay. In the garage, there were 15 rolls of rubber adhesive for like flooring, a compressed gas tank.
Oh, hey, Detective Shiner or Lieutenant Shiner, you might just hold off for a second. Judge, it looks like we just lost the defendant.
Okay.
We'll give him an opportunity to rejoin. Mr. Carter?
Yes, I can hear you now. I had technical difficulties. I was trying to object several times there, but my microphone on my laptop wasn't working, I guess, when it said it was. I do apologize.
Okay, it's working now.
Yes.
All right, we paused to let you rejoin. So now that you have, you may proceed further, Ms. Norris. We were talking about a list of items, 15 rolls of adhesive, and then a gas tank. And then I think that's when there was an interruption.
Yes, Ron, I think that's correct. So Lieutenant Shiner, if you would like to continue through a little bit more of your list. I think it's maybe broken down in like to 3 different parts. So you don't need to probably read everything from all 3 lists, but give a good sampling for the court if you would.
Okay. Purple Ergon tank, red snap-on toolbox, a Lincoln electric welder, DeWalt hammer drill, some extension cords, car batteries, some red, green, blue plastic trays, a gray job box, some vinyl cutting machines, an appliance dolly, a blue sample locker. There's a white otter box, and then some industrial electric cords.
Okay, and so were these found all in the attached garage?
No, they were found, most of it was found in the garage, but there was like a wooden box trailer on the driveway that had some of the stuff in it, and then in the backyard.
Okay, and the total amount, you know, in the approximate dollar amount recovered was what?
$14,110.
Okay. And all of that equipment that you have, that all of that you listed, and then everything else, because you didn't list every single item just for sake of time. Where is all of that evidence at this point?
Everything except for the dirt bike is at the Andover Police Department.
Okay. And the dirt bike is where?
I gave that back to Tim because Mr. Carter and Kayla both told me that is his.
No objection.
To objection, Mr. Carter.
He's not, he can't speak for me because I never told him that. I wasn't even there. I was in jail.
All right. All right. So noted. Let's proceed further, Ms. Norris.
Yeah, the objection is overruled.
It is.
Lieutenant, sorry. Did you said that Kayla told you that the motorcycle and that Mr. Carter at some point in time both had told you that dirt bike did in fact belong to the Bishops? When was that, and how did that come about?
That was before Mr. Carter went to jail. And then when Kayla showed up, she told me the same thing.
And when he went to jail, when was that?
The same day as the search warrant, so April 5th. We had a conversation before he was taken to jail, before we even executed the search warrant, because the dirt bike was in the driveway when we arrived.
Okay. And what specifically did he say regarding said dirt bike, the defendant?
Again, just like the first time we served the first search warrant, he told us that this is all civil. They owed him money. And then told us that we could take the dirt bike because it is his, but none of the other stuff on the search warrant was.
Okay. And did you have additional conversation with the defendant after you served this search warrant that we've been talking about and recovered all of this property? Did you have any additional conversation with the defendant?
After he got out of jail, yes.
And was it about the search warrant or specific pieces of property, or similar conversation to what you've already told us, which is he claims that it's civil and that's I think did you talk about them owing him money?
Yes, it was all of the above, everything you just stated.
Okay, so civil, and that they owed him money, and that
About the search warrant and specific pieces of property.
okay. So he doesn't actually deny that he had the property, or that a lot of the property that you recovered wasn't actually the Bishops or the total installations.
Correct.
And I know that this has come up basically just not necessarily as part of the prelim per se, but as part of even scheduling, et cetera. The Lincoln welder that you mentioned, how is that identified as the Bishops,
The Bishops
their
had
companies?
they had a photograph of it and the serial number for it. They provided when they listed out property that was stolen from them. And
Okay.
that's how they say. Go ahead.
And you had referenced it as a piece of equipment more in the concrete tools category and equipment, not necessarily, you had not specifically listed it out
Correct,
as far as a search warrant.
correct.
And all of these items that you recovered are all ones that the Bishops did not give permission, or the company did not give permission to the defendant to take from their warehouse or storage areas.
That's correct.
Okay. And have you talked to Mr. Carter regarding any of this property since we filed this case?
Yes,
Has he been calling you, emailing you, and what about?
both. And most of it's about the Lincoln welder. Mr. Carter says that was his welder and it was at the warehouse because he was using it to fix things when he was employed by them. And then he did provide a pawn slip from when he pawned the Lincoln welder. And I believe it was in September of 2022, maybe. So, and my only issue with that was after the theft was reported. He pawned the Lincoln welder and then went and picked it up.
Okay. Because the original theft report was November, December of 2021, right?
Yes,
Okay. All right. And so you requested charges on the defendant. What were the charges and based on what?
they were for theft, and it was based on the fact that they reported this property stolen, and Mr. Carter admitted that he did take at least some of the property, and then was selling it through Purple Wave, or at least attempting through Purple Wave and on Facebook.
And he claimed that they owed him money, but did you talk to the Bishops about that, or their company representatives?
I did, and they said that they did not owe him any money. And with my conversations with Mr. Carter, I told him that even if this was kind of a civil deal, he's required to go through civil court before he can just start selling people's property.
Okay. Lieutenant, I don't think I have any further questions. But Mr. Carter may have some follow-up for you, okay?
Okay.
Carter, questions for this witness?
Yes, sir. May I proceed?
You may.
All right. All right, Detective. You said that the Lincoln welder, they had the serial number to it. Which document do you refer to that has anything where they have a serial number written down for that Lincoln welder?
So I asked them to provide me with a serial number after we took it, and they were able to provide me a serial number that matches the Lincoln welder.
Well, yeah, they had photos of it after that, right?
No,
From our garage.
no,
Kim wasn't taking photographs in the garage with her iPad?
not specific items, no.
Okay, well, I do have video evidence of her actually doing that. Do you know that my Ring camera was working the entire time that y'all were there that day?
That's fine. She wasn't doing that.
Okay. Let me ask you this. When you first showed up, what happened and what did I say to you exactly?
Again, you told me that it was a civil deal and asked why I was there and doing all of this.
And why would I say it was a civil deal?
Because I believe that you believe that they owe you money.
No, that was not it at all. That was because I was storing the items for them and they never
Objection,
paid me.
Your Honor. It's not his turn to testify. Is there a question in here somewhere?
The objection is sustained. Formulate your
Sorry.
next question to
Sorry.
this witness, Mr. Carter.
Sorry. Do you not remember any conversations about them owing me rent for storing the items?
I do remember you telling me that.
Did Kim ever tell you that I was storing items for you?
No,
Your Honor, at this time, I would like to submit some evidence, some video evidence of this witness actually stating the opposite of what he's saying right now on the ring camera of accounts that had happened that day. But I'll let him go further. I got a few more questions before I do submit that, I guess, just to go ahead and nail this down. I do apologize. Okay. And you also said that I told you that the dirt bike belonged to Tim?
Yes.
You said I said that? And when did I
Yes.
say that to you?
You said that when we showed up with the second search warrant before you were taken to the Butler County Jail.
And you also stated that when you came to the house the first time on the first search warrant, that the motorcycle wasn't there.
Correct.
And on that list of stuff that you took, you said that you were the one searching through everything and Tim and Kim were kind of in the background looking over your shoulder. Is that correct?
Yes.
Okay. And they didn't search through anything themselves by hand, right?
They looked through some stuff, yes, after I looked through it, when they were verifying what was theirs. For example, like I'd pick up a container and it'd have stuff in it, I'd look through it. And then either most of it was Tim, he'd look through it, finding what was his.
Okay. If I was storing the stuff for them and had their permission to take the stuff to begin with, would that make this case criminal?
Yes.
It still would. How would that be?
After you started selling their property,
If so, can you state that statute of abandoned property for me? Do you know what that statute is?
I know what the theft statute is.
And what's the abandoned property statute?
I don't know what you're talking about. That's not a criminal statute that I know of.
Mr. Carter, I'm not going to get into an argument between you and this officer regarding.
I'm not arguing. I'm just asking him if he knows what the statute is. That's all.
I think he's answered the question. Let's move on.
Okay, then he was still talking. I didn't interrupt him.
Let's move on, Mr. Carter.
Okay. So whenever you showed up and arrested me right away, did you ever read me my Miranda rights?
No,
Ever? The entire time I was arrested?
no, and I didn't question you either.
Okay. Did upon my request, was I taken straight before a magistrate that day?
I have no idea.
I wasn't. I was taken straight to the jail. But either way, do you know what the procedures are for whenever you arrest a person out of your county's jurisdiction for a crime that may have been committed in your county? Do you know the procedures for that, to arrest someone, what you're supposed to do or whatnot? Whenever you arrest someone in another county from your jurisdiction without a warrant?
Yes,
And what would that be?
if I have probable cause to arrest you, for a crime that you committed in my jurisdiction, I can arrest you. And
I understand
typically
that.
we call the jurisdiction in which you're in to come assist us, which we did in this case as well.
Okay, what else?
That's it.
And what about if the defendant is request that time to be taken in front of a magistrate closer?
Mr. Carter, that issue is not before the court. This is a preliminary hearing to determine if there's probable cause that a felony crime has been committed and that you committed it. We need to limit the scope of the testimony to those issues. That's what's currently before the court, and this current line of questioning, it does not go to the issue of probable cause. So you'll need, if you have further questions that are relevant, you can ask those now.
Okay. So can I ask him, Your Honor, about his knowledge of the statutes of the Kansas law?
No.
I can't?
No. It's
Okay.
not, his knowledge of the law is not relevant to the issue as to whether the state is showing probable cause.
Okay. All right, I got you. So can I submit evidence of, well, the state has submitted evidence to me that that they're using against me, and one of those things are included are Tim and Kim's initial report of this theft, quote unquote. And do you, Amber, do you have that video available to play by chance?
Mr. Carter, I'm not sure what you're referring to.
The video from the detective or the officer that took their initial on 12/7 of 21 when they came in person to the lobby and made their report. There's 2 body cam footages of
Mr.
video.
Carter, I'm not going to require the state's attorney to submit evidence that she doesn't request to submit.
I'm asking, okay, I because I'm not on my laptop now, Your Honor. All of my stuff is on my laptop. I'm on my phone now because my microphone wasn't working on my laptop. So, but I'm gonna try to pull it up on my phone. I don't know if I'm gonna lose you. Can y'all
Okay.
still hear me?
All right, this isn't time for presentation of your evidence.
I'm not, it's testimony from Tim for him to cooperate with what he's saying that never mind, just do whatever, it's okay. Let me ask him a few more questions and I'll be done with him.
All right.
Are you still there?
Yes.
Okay, I'm trying to find my Zoom call here again. There we go. Okay. So you're also stating that there was stuff in the driveway in a box trailer, is that correct?
Yes.
Okay. Just to clarify though, whenever you came and arrested me right away, the first thing I said to you was that was Tim's motorcycle, correct?
I'm not saying that's the first thing you said to me.
Okay. But it was around that time though, right?
It was during that conversation.
Okay, before I was taken out to the car?
Yes.
Okay, just that's well enough for me. All right, that's all I need. Thank you.
No more questions then, Mr. Carter?
Nope.
All right, Ms. Norris, anything further for Mr. Shiner?
Not at this time, Your Honor. I don't know that I would necessarily need to recall Lieutenant Shiner, but I would ask that he stay with the meeting.
All right, very well. If you go ahead and mute yourself at this time, Mr. Shiner.
Yes, sir.
Thank you.
And Your Honor, one more brief witness, Tim Bishop. I believe he's in the waiting room. I think he was the iPhone, but I'm not absolutely positive.
Mandy, can you bring Tim Bishop into the meeting, please?
And I ask that the witness that just got off of the stand go back into the waiting room.
Request denied. He's completed his testimony before the court today, so he's allowed to stay.
Okay, well, the last hearing, I wasn't adequately, I didn't have all the evidence that the state had against me in front of me because they never provided it to me until like the 12th of this month. Tim and Kim are witnesses together in the same household. She was able to give her testimony with the other witness there, and now he's going to give his testimony with her there. And I still had questions for Kim as well. that I wasn't able to ask last time because I didn't have the evidence that I have in front of me now. So it wasn't a very adequate cross-examination, Your Honor.
Well, Mr. Carter, I'm not aware that there is a preliminary hearing right to discovery. So I don't think that that's really objectionable. Furthermore, I'm inclined under the circumstances to allow Mr. Carter's testimony, even though he may have listened in on his wife's testimony. The purpose of this line of questioning, Ms. Norris, would be what?
Your Honor, just to talk specifically about the tools and that kind of to confirm what Detective Scheinert had just been referencing and his ability to identify that sort of thing. I don't have a lot of questions for Mr. Bishop.
For that purpose, the court will allow his testimony. So, iPhone, if you can join with video and audio, please. Mr. Carter, your video went away.
Oh,
Okay,
sorry.
you're back.
Sorry, I'm trying to pull up evidence. Sorry.
Okay. Again, iPhone participant, if you could go ahead and join us with both video and audio.
Am I on
Your
You are
audio.
on.
audio? Let me figure out my video. There we go.
Okay. And this is Tim Bishop that you're calling as a witness. Is that correct, Ms. Norris?
Yes, Your Honor.
All right. Mr. Bishop, if you'd raise your right hand, I will administer an oath to you at this time. You do solemnly swear that the testimony you're about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
You may question the witness, Ms. Norris.
Thank you, Your Honor. Please state your name and occupation for the record.
Timothy Bishop, owner of Total Installation, partial owner.
And what type of things does your business Total Installation do?
We do commercial interiors for the most part, which would include almost anything on the commercial interior side of flooring, furnishings, that type of finish. Division 9, Division 10.
Okay. And at one time, did the defendant Mark Carter work for you?
Yes.
Okay. And in what capacity?
As a installer.
Okay. And when he was employed with you or thereafter, had you allowed him to take items from your warehouse?
When he had asked, I had allowed him.
Okay. And just give me an example of something that he would have asked to borrow from your business.
Our carpet stretchers, our tile equipment, that type thing.
Okay. And if he had asked to borrow it, you would generally say yes when he was employed with you?
Yes.
And as long as he would return it?
Well, absolutely.
Okay. And at some point, Mr. Carter stops working for you. Do you recall about when that was?
I believe that was mid-November or around there
Of
2021.
Okay. And after he stopped working for you, did you notice some items that had gone missing?
Yes.
And did you notice items that had gone missing over a period of time, or did you notice them all in like right after he stopped working for you?
That's hard to quantify. We had just moved product to a storage area from our warehouse. And so in organizing and moving that stuff around, I can't give an exact answer as to when I noticed it mostly was when my equipment disappeared, which was all at one time, basically.
Okay. And so you notice that you've got equipment that has disappeared. You make a police report.
Yes.
And did after it disappeared, did you end up adding additional equipment to it as you were you noticing other things missing, or did you really notice like one giant thing and then that's it?
Well, as I said, we moved out of 12,000 square foot warehouse. I didn't say that, but we did. It was racked to 3 levels high. So currently
It's a lot
on
of stuff.
site, yeah, a lot of stuff. On site over at my storage area, we currently still have 3 semi-trailers full of product. I've got a storage unit full of product, and I had product sitting outside. Also, when we moved out, that we couldn't come up with trailers for storage for that product. So it was set outside in the storage area, and then we were asked to move it around to accommodate the owner of the property.
Okay. So at any time after November of 2021, had you had any items that you were willingly storing, that you had asked the defendant to store on behalf of you or your company basically as a business agreement?
No,
Okay. And had you given the defendant permission to take any of, let's see, your Yamaha motorcycle,
no,
your Blast Pro shock blaster machine,
no, absolutely not.
a variety of miscellaneous tools, hand tools, welder, those,
No.
did you allow him to take any of those items after he was no longer employed with you?
No.
Okay. And were you present when Lieutenant Scheinert and the Andover Police Department served a search warrant at the defendant's house?
I was not there when they served it. No, we arrived after they had served the warrant, I believe.
Okay. So were you there and to help go through and find and maybe figure out if some of the property at that residence on Flint was in fact yours or your business's?
Yes.
Okay. And how did you go about identifying property as being yours and belonging to you or your company?
We had pictures from our warehouse and from our storage area of the products and items that we had taken, and so that's the items that we were looking for. I realize now there was more items in there that we didn't identify as ours. It should have been, but anyways, that's how we identified. We had our list, but we also had pictures of the products and equipment and things that were in our possession in our warehouse and at our storage. That I mean, I've been doing this for almost 30 years, and I've accumulated a lot of stuff, things that I know are mine. I mean, things that I can identify readily without having a tag on or whatever. It's I know the dings and the nuances of the tools.
Okay.
So
Give me some examples. Give me some examples of dings and nuances of the tools that would help you that helped you identify items that you were locating that day.
such as my tiles cutter. It had some of the pieces were loose that wouldn't be normally, and we've used some aftermarket parts to put it back together. Those are on it. I mean, there was simply a cash box in there that had our tag still on it. My carpet stretchers, they were, I believe, they still had a tag or two inside the poles on those. But as you use things, you become familiar with them. So that plus the pictures identifying specific things. I mean, there was a toolbox that I thought was mine that we pulled out, but then ended up not being mine. And so we put it back. Just that type of stuff. I'm sorry, I don't have any specifics of a particular.
Well, no, that's what you said makes sense. You mentioned tags on items. Tags is in like what kind of a tag?
There would be little metal stickers that we would use for our equipment for a job site. So we'd take them out and we would know what was ours to bring back.
And so what
They
would
had
it
total
say on the
installation.
tag?
It said total installation on the tag
Okay.
with our address, phone number.
Right. And did you have specific marks or paint or anything on your tools?
Some of that was we had hired a new guy and we were trying to 5S our warehouse, and so we had red paint on a lot of tools, but we hadn't made it through all of the readjustment of that to mark and identify all the tools with red paint, but some of them or a lot of them had red paint.
Okay. And that was a way you used to identify or to mark them for your knowledge as your company.
Yes.
Okay. And when the defendant left your employment in November of 2021, was it under good terms or no?
No.
Okay. Your Honor, I don't think I have any further questions. Thank you, Mr. Bishop. Stay where you are. I'm sure Mr. Carter's going to have some follow-up for you, okay?
Okay, thank you.
Mr. Carter, do you have any questions for Mr. Bishop? You ask the question, he provides the answer.
I do, Your Honor.
All right, you may proceed.
Okay, Tim, did your wife, Kim had testified the last time that we were in court that y'all were evicted out of your warehouse. Is that correct?
Yes.
Can you kind of give a little bit of a rundown and circumstance around that whole deal?
Objection, Your Honor, outside the scope of direct and not relevant to this particular hearing.
And how is
Yeah.
that relevant to probable cause, Mr. Carter?
Because it leads to the backstory of why I was storing the items for him in the beginning.
I'll give him some latitude here. Objection overruled at this juncture.
Thank you, Your Honor.
Could you repeat the question, please?
Yes, sorry. Can you kind of give a little bit of a background on why you were evicted from the warehouse in Bel Air in the first place?
It had to do with a larger story of an incident or a lawsuit from back in 2016 or 15 that was still currently going on at that time. We had been paying attorneys and had basically came to a point where we needed to downsize. We had made an agreement with our landlord about what our rent should be and things, but his kids took over and didn't necessarily abide by the agreement, but so we were evicted. I didn't want to take that to court, and because I really respected the landlord that I had for 20 years. So we moved out.
Okay, Mr. Carter, if you can now focus on whatever storage issue you were wanting to address.
Yes, and how long, just abruptly, how much do you think you owed to the landlord at the time of eviction?
Objection,
Zero.
Your Honor,
Carter,
not
I'll
relevant to
sustain the
probable
objection.
cause.
Okay, Tim, did you make any insurance claims on any of the stuff that you reported stolen at
No,
any time?
no,
To this day, you haven't made any.
no. I had no
Okay.
insurance at the time.
Okay. Did we have an agreement for me to store any of your items at all?
No,
Not at all. We never had a conversation about it.
no.
Okay, that's good to know. Your Honor, if I'm trying to pull up the video of his interview that totally impeaches this witness right now against what he's saying. How do I do that on this app on my phone? I have the video on my phone, but I don't know how to pull it up to submit it into evidence.
You're asking me how to present your evidence?
No, how to do it on the app. I could do it if I was in a court, in a real court in person with a video, I'd have it there, but I don't have that option because we're on this Zoom call stuff.
Okay. And the relevance of his prior interview?
It contradicts everything he's stating right now, Your Honor. It 100% contradicts everything he's saying right now. About not having a conversation about, he admitted all of that on the 7th of December in 2021 to the officer that took his initial report from him and his wife. I just watched the video this morning.
All right. Well, you can ask him about any inconsistencies about any prior statement that he's made.
Okay. So Tim, whenever you made your initial report on the December 7th, 2021 to the officer at the Andover Police Department in the lobby, do you recall what you told her that day?
No, I don't.
You don't at all?
Nope.
You just have no memory of even meeting her?
No, I met her.
Can you kind of give a rundown of a conversation that you had, if you had one?
I just said I don't recall what the conversation was. If I could see my video of it, I would clarify anything that's in there.
But so you can't recall anything you said to her whatsoever that the whole day?
That you had stolen property from us. Yeah,
And that's all you said?
I'm sure that's not all I said.
Okay. Do you recall any text messages that me and you had during that time frame as well?
I don't. My phone has been, I've been through 2 phones since then. Those conversations are gone from mine.
Okay, I still have them, thank God.
Okay.
Well, I do
If those
have
are
the
submitted as
evidence of
evidence,
the conversation, and I was gonna ask you, do you recall ever asking me why I was clocked in at an odd time that you didn't think I should have been clocked into the ClockShot app?
I don't recall that. No.
You don't? Okay. Do you recall paying me fuel for the box truck to haul the tools from the location at 13th to my house?
No, I paid you for fuel to take the products from the trailer that was at Larry's trailer to 13th Street in Andover, where our storage was. That I discovered that whole trailer's load of products gone too.
Okay, you mentioned Larry's trailer. Why was your Larry's trailer? Why did I have to go get this stuff from Larry's trailer?
Because it was on the trailer there.
And why was it at Larry's though? Why wasn't it out there at the 13th place where it had been?
Because they took the trailer to his place.
Because you didn't pay him rent?
We paid him rent. We obviously got the product.
So you were up to date current with him on the rent on that trailer
Yes.
that he repossessed? Okay.
He didn't repossess. I never owned it.
Oh, you were renting it, correct?
We ended up renting it. Yes.
Okay.
Having
Do you
some real
still have any
difficulty
trailers for him?
with the
Do you still
relevance
have
of
any-
all of this questioning, Mr. Carter. I don't see how it's
The relevance? the relevance, Your Honor, is he's renting trailers from a place where they came and repossessed. I was working out there at the time. They came and repossessed the trailer from him because they couldn't pay the rent for the storage trailer. So they came and took it with all of his stuff in it still. I had to go unload that stuff. He had nowhere to put it. He asked me to put it at my new place that I got. So I did. I felt obligated to help him out because they were going through a lot of stuff at that time.
All right, then stop there. All right, Mr. Bishop, based on what he just said, is that correct? What he just related?
Well, I'm sorry, which part?
Okay, fair
There
enough.
was no
Fair enough. The
repossession
part
there.
where supposedly you wanted him to store some stuff for you because you didn't have another place for it.
No, he was supposed to be taking it to 13th Street
All right.
to our storage area.
Okay, so at the 13th Street storage area, were you getting in trouble for all the stuff that was outside?
No,
Your Honor, he
I still
just
have storage
testified
there.
to it earlier that he did, just a few minutes ago. You had to move it
that
around.
had nothing to
correct?
do with what was there. It was where it was at there.
Okay. So you weren't getting in trouble for the stuff that was stored out there at 13th Street?
My product is still there, part of it. I mean, the part
That's
that
not my
you haven't
question.
taken.
I'm asking you, you just stated earlier, you were getting in trouble for the stuff that was up there being stored. Is that correct or not?
No, my product is still there. It was the owner asked me to move it from where it was, which we had done.
I'm not following. Can you repeat that again? Explain that a little better.
It's a large lot. He asked me to
Okay.
move it away from the building, which we
Okay.
did,
And where did you move it to?
away from the building.
And what exactly did you move?
Objection, Your
Whatever
Honor,
was-
relevance.
Objection sustained. Mr. Carter, I again, you may see that there's some sort of relevance to this line of questioning, but the court doesn't. When it
Okay,
comes to
well, Your
narrow
Honor,
issues which are currently before the court.
he just testified just a few minutes ago that he was getting in trouble by the owner lot up there, that he had to move the stuff from the location.
All right, he's given his explanation, Mr. Carter, so
Okay, but then
Where are we
he
going
goes
with it?
against that. He went right against saying that, so. Okay, relevance, I guess not, right? But anyway, so the welder, did you ever have any text messages with me about the welder? Me coming up and welding anything on the trailer that broke during the time that we were loading everything out of the warehouse? When you were evicted?
Mark, I don't have those text messages. I don't remember.
But do you remember that time frame, right?
Do I remember that time frame?
How did you
Yeah.
obtain the welder from me in the first place that you claim is yours?
I didn't obtain it, Mark. You brought it. You traded it to me when you took the carpet out of the warehouse and the bedroom suit that we traded,
Well, I traded you the welder for that.
along with a torch, oxygen, and acetylene, a setup. And you were supposed to give me 2 toolboxes, of which you gave me 1.
And I was supposed to give you a welder too. Is that what you're saying?
Yes.
Okay. Well, I have messages for that as well. Now, let me ask you, did you, hold on, let me backtrack a little bit. When you found the box truck, where was it located?
In front of your house
came
on
to-
Flynn.
Whenever you came to get it for the last time from me, where was it located?
I found it on Flynn. You didn't tell me where it was.
Okay. You found it on Flynn. It was on Flynn's, was it in front of my house or down the road from my house or where?
Got pictures of the area, but it was right by your house.
Okay. And it wasn't a few streets over or anything like that?
Objection,
No.
Your Honor. Again,
Okay.
relevance to probable cause for this charge has nothing to do with the box truck.
the objection is sustained.
Well, it has to do with the credibility of the witnesses, Your Honor, because they are obviously can't keep their story straight. His wife just testified the last time. they had the
Objection, Your
hearing
Honor,
that
he is
the box truck was found a few streets over.
testifying.
Mr. Carter, I've made my ruling. The objection is
Yeah.
sustained. If you have other
Okay.
questions for Mr. Bishop,
Yes, I do.
Okay.
So did you have the serial numbers to the Lincoln welder prior to the search warrant being conducted that day?
I believe so, yeah.
You believe so? How would you have gotten that?
It was in my warehouse. There's pictures of it, Mark.
Okay. When you left the warehouse, did you leave anything in the warehouse, or was it completely empty whenever you were evicted?
There was still product in the warehouse.
How much product was in the warehouse do you estimate?
Mark, that's a hard estimate to throw. I've got pictures. We've been there since. We've been,
Okay.
I get along with the landlord fine, Mark. We've been back over there and picked up product. I've taken pictures and videos while I was in there.
Would you recognize this letter right here from your landlord? Hang on. Can you see that?
It's very, very small. I mean, what's the point?
Can you read that though?
No, I can't.
You say you're on very good terms with the landlord. That's Buck Alley right there wrote that letter.
okay, how is his relationship with his landlord relevant to the issue of probable cause here?
Because I'm breaking his character witness down, Your Honor, because he's lying again. And I just spoke with Mr. Buck Alley just 2 days ago, and I've got the letter from the guy. He signed this. He typed it up himself. This guy's he's like 90
Objection,
years
Your
old.
Honor. Mr. Alley is
And-
not present, and I still don't see the relevance.
Okay.
So hearsay and relevance.
Carter, I also stain that objection by the state's attorney. Again,
Okay.
focusing on the elements of the crime in this case,
Okay.
Mr. Carter.
Tim, how come you didn't report your dirt bike supposedly stolen back whenever you made the initial report for the truck in 2021? When did you report the dirt bike stolen?
I don't recall which I mean, when we made the initial report, I was expecting detectives to contact us and follow it up. So there was a few initial things, obviously large stuff, such as my shot blaster and my large grinder, which both of those I used to make a living at, Mark. That were missing. So those were part of the initial statement, but I believe part of my initial statement probably would have said a bunch of other stuff. So a bunch of other stuff is, I mean, I still don't have a complete, I mean, there's still things coming up missing. So
are you implying that I took those as well?
I'm not implying anything, Mark.
Okay, I'm just asking. Okay. Now, the tools that were there at the 13th storage, were they stored inside or outside, Tim?
Outside.
And are these electric tools? Do they run off of power? They got electric motors?
Some.
Most of them? The big
Some.
machines like you're talking about, like the shot blaster?
Yes.
Okay.
That's why we
Is
had
the
them
weather
tarped.
good? Are they weatherproof?
No, that's why we had them tarped. That's why I paid you to tarp them.
And did the tarp stay on them all the time?
They did after I reattached them.
After you reattached them? Okay. Nothing got ever wet out there ever?
They could have.
Okay. So how much, and as expensive as those machines were, you didn't have anywhere to store them inside, correct?
At the time, no.
Okay. And at the time, correct? So there was never a time where you were having me bring the tools out from my place where I was storing them to bring them to you or to Jimmy, our other employee there. Was there ever any of that kind of a back and forth at all?
From what I recall, you had taken something to fix it, and we had asked for you to bring it back, which you did not
To fix
until
what?
after we had needed it, and that was done.
To fix what?
I believe that was a one of the scrubbers, or not a scrubber, but a buffing machine or something like that. And I think you had some of my grinding bits for the grinder, which I'm not sure why you had, but I asked for those back, which you never responded, never brought back.
I never responded back to you.
On those? No.
Okay.
Not that I remember. I mean, like I said, you have the text, obviously.
Yes. So, but we did have back and forth conversation about tools that I'd had during this time frame of November, mid-November, correct?
Some small pieces. Yeah.
Bits and small pieces, nothing big.
Mark, you've got the texts.
Okay, I'm
Put them in front of me. We'll talk
just
about
asking you to recall from your memory, Tim, because you have a memory, correct?
I sure do.
Okay, well, that's why I'm asking. So
how much did you ask me? Or never mind.
the box truck, you stated that there was something wrong with it whenever you picked it up.
Your Honor,
Relevance of box
relevance,
truck
again,
Questions here, Mr. Carter. I agree, Ms. Norris.
Okay, sorry.
I don't think the box
my
truck
bad.
is at issue here.
Well, it was reported stolen and they claimed that I stole it and I never stole anything from them.
Okay. Doesn't appear to be part of the charges in this case, so.
And speaking of the charges, what are my charges, Your Honor? Because they charged me with theft and then I got another charge that nobody ever even told me about a few weeks ago. I've seen it online. I never even was served any papers about that.
Your Honor, might we finish with testimony before we get into amended informations? It is not a felony
I
charge,
agree,
so
I
it's
agree.
not
I agree.
part of this preliminary hearing.
All right,
I
fair
agree.
enough, Ms. Norris. Anything else for this witness, Mr. Carter?
Hold on, let me read through my notes real fast, sir. Hold on, let's see. When you were at my house doing the search warrant, were you the one conducting the search there that day, or was the detectives doing all the work and you were just kind of looking around over their shoulders, not going through stuff?
The detectives were pulling and recording the product.
Okay. Do you know were you aware that I had a Ring camera up that day recording as well?
No.
Okay. Do you recall taking anything out there that didn't ever belong to you prior to your abandonment of the property whenever you didn't pay for the storage cleaning?
What was the question?
I said, did you take anything from the garage that day or my house during that search warrant conducting that had never belonged to you or that wasn't a part of the abandoned property that you didn't ever pay storage on?
There was no abandoned property.
There was none? You didn't abandon the property to me whenever you didn't pay
No.
me for the storage?
Is there anything? Did you have anything saying that you charged me storage for something?
We had a verbal agreement.
Oh, we did? I don't recall that at all.
And we do have back and forth conversations over text messages that
Of an amount or what? What's?
not necessarily an amount, but the fact that I was on the clock working during the times that I moved it. It's even
Objection,
shown
Your
on the
Honor.
PDF.
If Mr. Carter wants to testify, this is certainly not the time for it.
I understand.
Court agrees. Any other questions that Mr. Bishop can answer?
Yes. Let me look through. I'm almost done, Your Honor. Did you ever tell the detectives that I was storing any items for you at all during any conversations or reporting?
I don't recall, Mark.
Do you recall?
I
Kim,
sure as
ever-
heck didn't tell you to sell anything.
Okay.
If you were storing anything, I don't recall that. I don't recall having a conversation with you about storing anything.
Okay. Do you recall if Kim ever told the detectives that I was storing any items for you or Kim?
That
Objection,
would be
Your Honor.
hearsay.
That's a whole other witness who has already testified.
Sorry.
And
All right. Next
Um,
question, Mr. Carter.
Yes. Was I a good employee, Tim,
Most of the time,
most of the time? Did you ever have any trust issues with me? As far as like taking stuff that didn't belong to me and whatnot?
not until the end.
Okay. But for the most part, I was a very loyal employee to you and through all the thick and thin that your company and your wife and your family had gone through at that time, correct?
I don't know that I would
Objection,
call
Your
that
Honor.
loyal.
relevance.
Objection sustained. Carter, let's stay on task.
All right. Okay, I guess that's all for now, Your Honor.
Any
Thank you,
follow-up
Tim.
from Mr. Bishop?
I don't believe so, Your Honor. Thank you.
All right. Bishop, you can go ahead and stay with the meeting if you like, if someone asks you to mute yourself at this time, or you can leave it at your choice. Okay?
Okay, thank you.
All right.
And Your Honor, I have no further witnesses at this time. I'd ask that all the witnesses be brought in so they can all be allowed to leave at this point,
Andy, go ahead.
if they so choose. And Your Honor, I would make an amendment on the record to add basically an alternative of possession of stolen property for, and I would specifically add the Lincoln welder, and I will amongst the miscellaneous tools. And I think that's it for my on the record amendment.
Would it be level 9 non-person felony theft charged in the alternative?
Correct, Your Honor.
All right, and I trust you'll be following this up with a written amended information.
Yes, Your Honor. Thank you.
Mr. Carter, anything you want to say about that?
Oh, yes, Your Honor. I believe I've already provided text message or email proof that before 2021 that the welder was mined in pawn shop and had because I'd weld with it and then I'd pawn it when I needed the money and then I'd get it out. Okay.
That goes to to defense of the charge against you rather than the state's ability to charge it.
Okay,
It's
that's
going to
fine.
allow the amendment, and I'll direct the prosecutor's office to follow up with an amended information in writing filed with the clerk's office as soon as possible. Anything else, Ms. Norris?
Not from the state at this time, Your Honor, other than if the witness would like to be released.
Oh, indeed. Mr. Snedeker, and then I think there's a Mr. York and Mr. Sign, is that correct? All right, all of you apparently, and Kim Bishop, apparently all of you may have been asked to be present to testify today. The state's concluded their presentation of evidence at the preliminary hearing. I can release all of you from the meeting at this time if you so desire.
Thank you.
Thank you. Thank you for your patience this morning. right, Mr. Carter, do you intend to present evidence at this hearing?
I do, but like I said, my laptop is the only way I could do that. If I presented the evidence, I'd have to get on and log back onto my computer through the Zoom, but I would not be able to communicate via voice through the laptop. Is there a way that any of your staff know that I could keep like a phone call going or audio through my cell phone on a phone call or something, while I can do the Zoom video and evidence presenting on the Zoom through my laptop?
All right. First of all, Mr. Carter, it's really unusual. In fact, I'd even use the term highly unusual for the defendants to even present evidence at a preliminary hearing. And there's one fundamental reason for that. And that is that when there's a conflict of evidence, this court at preliminary hearing stage must resolve those doubts in favor of the state's position. In other words, looking at the evidence in the light most favorable to the prosecution. So if you're challenging the state's evidence or credibility of a witness, the state is still entitled to a favorable determination from this court at this juncture regarding any disputed issue. So what is it that you were wanting to play? And what is its purpose?
Its purpose is to impeach every witness that the state has had on the stand at this moment. Every witness that they've called has contradicted what has on my records and through the court records that was given to me through the discovery is a straight 100% contradiction to the testimony that was given today and prior by all witnesses. And I was going to ask you if I would be able to present that today. If I know that I have technical difficulties, and it would be easier for me to explain it, or can we call for a special hearing that could get me another laptop and download everything on it, and maybe in another week have a special counsel hearing to present my evidence for this? That would, because it's very straightforward, and it's audio and video recording mostly of contradicting testimony that was just given to what they've stated that they did not say, including the detective.
And Your Honor, I have no idea what this evidence is. I have not received anything from Mr. Carter.
Your evidence that you gave to me through the discovery was one of the videos that was Tim and Kim Bishop giving their interview on the 7th of 2021 in December. It has Tim Bishop clearly stating that we were having back and forth. I was having tools and he was getting tools from me. And even the detective the lady taking the interview stated, so he was storing stuff for you. And
Your Honor, I would object to him testifying about a video that he did not create, or that he is not present for, or that he has no, records custodian, etc., to present.
you presented it to me through the evidence. It's in the discovery.
I'd still make the same objection, Your Honor.
Which the court will sustain. Mr. Carter, do you intend to present any witness testimony at this hearing?
I didn't know I was allowed to, Your Honor. I thought it was the state's burden to prove
It is.
Okay, and let me ask you this, Your Honor, am I presumed innocent by the court at all times until proven guilty?
Yes.
And you're the one that upholds that, correct?
I do my best to do so, Mr. Carter.
Okay. And I expect that from the court here. As far as the evidence that would be more in light in favor of the prosecution at this stage, isn't this the only time I can present my evidence and arguments before a plea, before I waive any rights to any such arguments? I'm not asking for advice, I'm just asking a direct question of the court.
You're entitled to a trial on the merits. I presume you know that.
Yes.
That is not what today's hearing is. your guilt or innocence will not be determined today, Mr. Carter, but
Oh,
rather
I understand that.
at a
But if
trial.
I can show now, before even a trial has to come, the evidence that contradicts testimony from all the witnesses that the state has brought forward in their offense and against me, is saying that I've committed a felony crime here. To the contrary, I have enough to hold all of them in contempt for you to be able to do that, because it does. I know that I don't have the money to pay for the testimony to be recorded back through verbatim, or through however the recorders do
Transcribed, you
that.
mean.
Transcribe,
Transcribed.
yes. I don't have the money to pay for all of that. I don't, but I would like for a copy of all the witnesses' testimony in verbatim and to be transcribed, to go back over with the video to show the court exactly what I'm getting, my point of view here and my arguments. That's the only way to do that. But I'm at a part where I don't have the money to afford to have that transcribed on any of it, but I need it.
All right, have you filed a written motion with the court for that recording or that witness testimony?
No, I did. I was directed that you would have to, that's why I emailed, and I do apologize for that.
We're not going to deal with resolving motions by email, Mr. Carter.
Okay, I understand that,
Okay.
but I was just directed that I had to contact your office through that if I was to obtain that without a court order. So if I have to file a motion, I will. Can I get the ability to be able to file motions electronically, so I don't have to drive all the way out there to El Dorado?
I don't think that the Kansas Supreme Court has authorized pro se individuals to electronically file.
Okay, I was able to do that in a pro se case against an employer of mine in federal court. I was able to electronically file.
This isn't federal court.
I understand that. I just didn't know if it kind of correlated into the same system or not.
No.
Okay. There's no way to get special authority to do that.
Not that I'm aware of.
Okay.
Your Honor, are we complete with prelim?
We're getting there, Ms. Norris. We're trying to get to that. I'm just as interested in that question being resolved as you are. Mr. Carter, so where are we here?
I would like to present my evidence in the contrary to that, but I would like to set up a hearing for this so I can have my electronics working, where I can be able to upload it through, because we're limited on the Zoom here. It's not in person. I could have it in person. If we had a hearing in person, it would be a lot easier to present it because I'd have it all with me. But on this, there's technical difficulties, and that shouldn't hinder my ability to defend myself here. You understand?
Okay. Well, Mr. Carter, I'm just trying to let you know, I realize you're not a trained lawyer, even though this court has admonished you in the past that you would benefit greatly from having an attorney represent your interest. You've insisted on representing yourself, and you do have a legal right to do that. But I also need to inform you that prior to the trial, the court is not going to, except for certain limited circumstances, I'm not going to get into credibility issues regarding the witnesses. Again, the state's entitled at this juncture that if there's conflicting evidence, even if you present something to the contrary, I have to resolve those doubts and consider the evidence in the light most favorable to the prosecution at this stage. Now, that doesn't hold true at time of trial, but it does at this stage. So if you're going to present a video, which I'm not even sure you've laid a proper foundation for, or even have the ability to present, purely for the purpose of impugning various witnesses' testimony, it's probably a futile act on your point, because this court must construe the evidence in the state's favor if it conflicts.
If it conflicts,
With anything you've got to present.
either way, I still would like for the court to allow me to present that and take that matter up before trial. just to, if we can avoid trial, I would rather avoid trial. I don't want to have to, and if I have to obtain a lawyer, I don't want to have to pay for a lawyer for trial if I don't have to. That's why I want to present. If there's a conflict, from what I understand, if there is a conflict in the evidence or testimony, and there's evidence to provide to the court that would totally be exacerbating to that, like it totally, whatever and I have to file a motion for the prosecution as well. That I'm busy writing right now on my motions, actually, to file to the court before I do any pleading or any of that. I want to get it at this stage here while I still have my rights and they're not waived in any way. And I want to reserve all of my rights here moving forward as well throughout this entire proceeding, without prejudice, because I'm being accused of a felony wrongfully by bad actors here. Even now,
Now you're making argument here.
I'm pleading to you that I need to submit evidence to the contrary. Even if you can't weigh it in my favor, that's fine. I want to get it on the record, and I'm just not allowed to do that like I thought I was earlier, because my microphone is not working on my computer, and I don't want that to be.
Your request to continue this hearing is denied, Mr. Carter.
Okay.
I mean, this is the second hearing, not the first, and you were quite aware that we were going to be continuing the hearing by Zoom, and I would have expected you to make any technological arrangements necessary to present any evidence that you intended to present, including laying a proper foundation before any videos or audio recordings are played. So,
And what would be the proper foundation to lay?
I'm not going to give you legal advice.
Well, I'm asking you. That would be that would impeach everybody that was on the stand, Your Honor. That I have direct evidence to put in front of your face to let you judge for yourself, that says this guy said something that was not true. 100%. He lied directly to my face. He said the opposite of what he said on the video at my house on the Ring camera.
Your Honor, I object to him testifying and or, dragging people's, testimony through proverbial mud at this point without.
Your objection has merit, Ms. Norris, and the court will sustain it. Really, we're just getting down to a fundamental question. Are you going to call any witnesses today, Mr. Carter?
I'm not going to call any witnesses today besides myself.
Besides yourself?
Yeah,
Okay.
and I will testify myself.
So if you're going to consider testifying, the court's going to admonish you at this point. You understand that anything you say in this hearing can be used against you in any further proceedings, including your trial on the merits. You understand that? Your jury trial or a trial to the court or whatever the case ends up being. Anything you say today, if you say anything incriminating, can be used against you. Do you understand that?
Let me see.
Also, I need to tell you that you've proceeded on your own. I must caution you about trying to proceed with your own testimony without an attorney's advice or assistance.
Okay. I will hold off on testifying today then. And if I could, what is our next stage after this, Your Honor?
Well, I have to make a ruling on probable cause first.
Okay.
Which, since both sides have rested, I can now do. The court does find that the court finds probable cause from the evidence presented that the defendant, Mark Anthony Carter, has committed the crime of theft, a level 9 non-person felony. That felony crime has been committed, and that the evidence does indicate that Mark Anthony Carter committed it. So he is bound over for trial on the felony charge of the information, noting that it is now a charge in the alternative. We're going to proceed to formal arraignment at this time. Except, well, perhaps I'll have to continue that because I don't have the current charging document before me. Were you asking for a reading of the information, Mr. Carter?
Yes, I would also, I'm going to file a motion for,
Okay.
I'll just do it in
My
writing.
question
I'll do it
was,
all in
do
writing.
you want the information read to you?
Yeah, no, I don't. Not at this time.
All right.
I know I would like it. To
So,
be filed.
all right. Very well. And then what plea is being entered, Mr. Carter?
I'm not gonna plea at this moment because I want to present my evidence
All right,
before I plead.
that's fine. And then the court will enter a plea of not guilty on behalf of the defendant. And we'll
How do
start
you
with-
move how are you moving the court without my consent? on that?
Because you declined to enter a plea, the court will enter a plea of not guilty. I'm sure
I
you
didn't,
wouldn't want me to enter
I
a plea
just
of
said at
guilty.
this moment, I didn't say I wouldn't.
Well, but this is arraignment and it's time for you to enter your plea. So I'm going to enter a plea of not guilty. Set this matter for both pretrial conference and jury trial settings.
Well, I don't want to waive any rights to my defense either, or my arguments at this
I don't-
time.
I don't think anything is implicit here that you've waived anything, Mr. Carter. Except maybe your right to have the information read to you. All right. I'm going to set pretrial conference the week before the jury trial, which I'm going to put on the docket, Ms. Norris, of Tuesday, October 3rd. Tuesday, October 3 is day one, 9:00 a.m., unless otherwise announced later. October 3, 9:00 for jury trial.
Your Honor, I'm not going to be available on the 3rd or 4th.
Is that because of a conflict on trial?
No,
Okay,
personal.
fine.
Does the court have a September date?
I do. I'm looking
I
now.
can't
to
do
see which
September,
day.
Your Honor.
What's that?
I can't do September.
Why?
I have family that comes in around that time, and we do a lot of, we're never around the house at all with the kids because it's right at whenever they're at school, we're visiting. And when they're not at school, we're out in one of the lakes here in Kansas visiting. And that's just the month of September for our family. That's an every year occurrence.
Ms. Norris, if you would take a look at your calendar for Tuesday, October 31.
I'm sure that'll be fine, Your Honor.
Very well. We'll set day one of the jury trial, 9:00 a.m., Tuesday, October the 31st. We'll set a pretrial conference the week before. I'll have to set that early in the week. $11 a.m. on Tuesday, October 24th.
October the 31st.
No. The pretrial conference, which is a mandatory hearing that we conduct prior to the trial,
Okay.
is
And that's on
Tuesday,
what day?
October 24 at 11:00 a.m.
That's fine by the state, Your Honor.
All right, I'll set pretrial conference there. That is a mandatory appearance by Zoom for you, Mr. Carter. October 24th, 11:00 a.m. Obviously, all stages of the jury trial, if it goes on the October 31st, will be in person. So pretrial conference, 11:00 Tuesday, October the 24th.
Is that with the jury? My peers, correct?
No. Pretrial conference is the week before. It's a hearing we do by
But-
Zoom, essentially
But
to
the jury
talk
trial
about,
is though, correct?
talk about the trial, for lack of a better way to explain it. And to see if the case is resolved by then, which seems like it's not much of a chance here, but court remains optimistic. So let me repeat one more time, Mr. Carter. Your pretrial conference by Zoom, mandatory appearance by you, is Tuesday, October 24th, 11:00 a.m. Your jury trial is set to begin October 31, 1 week later at 9:00 a.m. You must be present for all stages of that jury trial if it goes. I again highly advise you to consider the retention of counsel to represent you, Mr. Carter. And if you can't afford one, you have a right to apply for court-appointed counsel. All
And
right,
Your
court
Honor,
date set. Anything else, Ms. Norris?
Your Honor, before we go off the record, I just would ask that if Mr. Carter does have any video or text messages that are his, that he should talk to law enforcement about those as far as evidence. If he wishes for the law enforcement to view them or for the state to see them for purposes of the case, he would need to contact law enforcement for anything that he has himself, as opposed to myself or the court.
Why wouldn't I submit it to you, the prosecutor and the court at the same time?
You submit evidence through law enforcement, then they can look into it and forward it to my office. You submit nothing directly to the court until trial.
So I can't, even motions,
No,
Well,
you can
motions,
file your
yes.
motions with the clerk.
but the evidence to go along with those motions, I can't present to the court.
Only during a scheduled hearing, Mr. Carter.
Okay, I wasn't
Again,
aware of that.
according to the rules of evidence.
Okay. All right, I'll have to go back and look over that as well.
But I'll just note that the prosecutor's request is that if you're going to submit or you intend to submit anything as evidence that essentially she hasn't provided you, it needs to go through the Andover Police Department. Is that the proper agency?
I'm sorry
Yes,
about
Your Honor.
that.
She's requesting that you submit it to them with an explanation that you intend to present it as evidence in your case. And I'm
Okay,
sure.
and that's anything that I have of myself and not the evidence that she has given me in the discovery, is that correct?
Correct.
Okay, so anything that is in the discovery, I can use to file with the motion, correct?
Well, I'm not
Within
going
the rules of evidence.
Yes,
Yeah.
I'm not going to rule in advance on foundation or any other issues that might exist in your presentation of evidence. And again, Mr. Carter, an attorney's assistance would be very valuable regarding that.
Okay, and I do have one question. I do remember at the beginning of the hearing, I heard the word burglary tossed around with theft. Is that a charge that I have currently?
Ms. Norris,
Not in the information as filed, Your Honor.
or in the amended information?
No, Your Honor, there's never
right.
been a charge of burglary filed.
Question's
Okay.
been answered then, Mr. Carter.
Thank you. Thank you.
Anything further, Ms. Norris?
No, Your Honor, thank you.
Mr. Carter?
No, thank you.
Very well. If there's nothing further, the Carter matter will currently be in recess. And Mandy, you may end the meeting.
Hey everyone. I have got an update to Mr. Carter. He was a handful the first time we saw him, and he went pro se to defend himself against his former employers who he reportedly stole like all of their business equipment. I tried to condense the case down, and I'm not even sure how to do it. So, and if you want to watch the whole thing, I'll put a link in the description. It is 2.5 hours long. I highly recommend watching it on like 1.5 speed because there is so much dead space, and this lady just talks and talks and talks in circles and can't answer a question concisely at all. But let's get to the update hearing, which I've only watched a little bit of, but so far is way crazier than the first one.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Mark A. Carter. It's case number 2023 CR 194. Mr. Carter appears still representing himself in the case. Amber Norris appears on behalf of the state of Kansas. This matter last came before the court on August the 22nd. At that time, the court established pretrial conference and jury trial dates, with the pretrial conference obviously for today. Jury trial was set to begin October 3rd at 9 o'clock. At that time, Mr. Carter argued an oral motion to dismiss based on insufficiency of evidence. Court denied that motion. Court also denied a request for return of a toolbox and welder. Ms. Norris had asserted to the court that this was being held as evidence in the case or on good faith suspicion of theft. The court ordered the county attorney's office to provide an affidavit supporting the search warrant from April the 5th of 23 by email within 7 days. The defendant was again informed by the court of his need for retained or appointed counsel rather than representing himself. The court noting that he was still desiring to proceed pro se. Ms. Norris was to draft a continuance order. Since then, there's been 2 motions filed, which we'll address today. One is entitled Defendant's Motion to have Assistant County Amber R. Norris held in criminal contempt.
Did he seriously just say criminal charges against the prosecutor?
And affidavit. The other, motion for transcript of court proceedings held on Zoom. Are you still wanting to pursue a contempt citation here, Mr. Carter?
Your Honor, she was not complying with your order. That was my only way to bring it to the court's attention that I know of. So she has complied with the order since, but it was way late, and she did not email it when she did comply on the lateness of the original uploading of the document to the DocuShare website. And it only after the motion I filed was the email sent to me.
All right, Ms. Norris, do you want to address that?
Sure, Your Honor. The court had ordered that we comply within 7 days. When I returned to my office and I went through our file, we actually did not, we had the search warrant, but we did not have the affidavit and application. So we had to request that from law enforcement. They did not. We requested it several times over the course of the 7 days, and we did not receive it until I believe the 13th. And that's the day that we sent it through DocuShare, and the defendant opened it, downloaded it. And because we could see when he looks at anything and when he downloads things from that program. And I think since it took longer, obviously, because we had to wait for law enforcement to provide it to us. And then the motion was filed after he had already had, after it had already been uploaded to DocuShare, after he had already had access to it, and after he had already repeatedly emailed me regarding same. Then he filed the motion for contempt. So he actually had it, but we, I think in our office, there was a little bit of confusion. We normally send discovery through DocuShare. And so when we got the affidavit and application, it was sent the normal way we do discovery, instead of specifically by email. And then once I realized that it hadn't officially been sent by email, but that he had already had access to it, I did go ahead and send it by email to be in compliance with the court's order. But I think that was just really an oversight. But the reason that it was longer than 7 days is because I could not produce what I did not have.
All right. The court is prepared to rule on the contempt motion that was filed by Mr. Carter. First of all, it would not appear to the court, at least from the content of the file before me, that Ms. Norris was ever properly served by the sheriff with the contempt citation as Kansas law requires.
It's a good thing it's Judge Ricky hearing this case, and you know, he has that stoic, straight business appearance, because I think most other judges would have laughed and had a hard time covering it up. But he didn't even bother to serve her. Come on. I thought you were an expert pro se.
Further, the motion in this case is not really one based in criminal contempt, but rather civil contempt. And because it's meant to try to compel compliance with a court order, the remedy that the court would be seeking would be to try to compel compliance and try to take steps to compel compliance. The county attorney's office has already complied. Furthermore, the 7-day order was more directory in nature than mandatory. It presupposed that the county attorney's office was in possession of the affidavit. They apparently weren't. It does appear that the county attorney's office took reasonable steps to comply with the court's order anyway. And even on its merits, the motion fails. So at this time, the court will deny the motion to hold Amber Norris in criminal contempt for the reasons stated. And we'll move on to the next motion, which is before the court, a motion for transcripts of court proceedings held on Zoom. Mr. Carter, I note this wasn't even filed until September the 14th. You're requesting transcripts of a preliminary hearing which took place in July. Further, your motion for transcripts, I think for the first time, is making the allegation that you are indigent. You've never submitted a financial affidavit which sets forth your financial assets to let this court make a determination whether you're indigent or not. But even presupposing that you are, this is a very belated request. We are set for trial next week. And you didn't file a motion for these transcripts, which you claim are critical to your defense, until September the 14th, which I find curious, to say the least. Furthermore, without having made a prior finding of indigency and without a financial affidavit, I'm in no position to be able to determine that you can't afford them. I mean, when these hearings were over, you could have made a request to court administration for a transcript of this, received an estimate of cost. Did you do that?
Yes, sir, Your Honor, I did.
All right. What was the estimate of cost?
Several $100 per
Excuse me?
hearing. Several $100 per hearing.
Several hundred dollars. Okay. Obviously, unless you are found indigent by the court, you have to pay for that yourself. Furthermore, I'm not currently aware, nor am I aware exactly what your theory of defense is. That will obviously come out at trial, I think. But I don't know that they're necessarily critical to your defense. Further, you made a request for a hearing that wasn't even evidentiary, saying that you think that that was critical to your defense. It's difficult for this court to understand how a non-evidentiary hearing and the transcript of that would somehow be critical to a trial defense. Can you fill the gap on that one, Mr. Carter?
Yes, sir, Your Honor. It was statements made by the defense. I mean, not by the defense, but by the prosecuting attorney, Ms. Norris, as to hold her to what was actually said in court on the ruling and your ruling as well for the return of my items of my welder and my toolbox.
So just to explain that one real quick, he stole everything from his former employers, saying that they asked him to store the items for them and then never picked them up. And then they owed him money and then all these different things. And then he didn't do it. He has 20 different defenses, but in return, he's saying that they have a welder that belongs to him in a toolbox and he wants those back. And he is very adamant that he wants those back. And that is what he's referring to as the things that he wants back, you know, regardless of what he actually took of theirs.
Where I feel like it is I don't feel like you've remained impartial with this with that section of this case, Your Honor. Respectfully here, I feel like you're biased in a way because I know that you work with Ms. Norris, and as you even stated so in your finding of that ruling, that you've never known her to lie or whatnot. I can't remember exactly how you worded it, but it was along those lines. And you said on that alone that you're gonna let her hold the items from me and continue, even though I have evidence that she has the evidence that clearly shows by the photos that those toolboxes and the welder has never been their items to begin with, and they never owned them. They weren't in any possession of them at any time. The Snap-on toolbox, he's never even had it at his shop to even consider it be his.
All right. Identity of the ownership of those items. Can you mute yourself again for a minute, Mr. Carter? All right. The ownership of those items may indeed be an issue for trial. However, Ms. Norris will not be a witness. Her statements are not going to be held as evidence in court. So anything she said during the motions hearing isn't really going to be relevant for purposes of the trial. Determination of that ownership issue has to be based on evidence that's presented there. And I can assure you that Ms. Norris will not be a witness. So again, it wouldn't appear that there is a legitimate issue stemming from that motions hearing where there's even a colorable claim that you're entitled to a transcript. Further, the court, even if you're determined to be indigent, which this court has not made such a finding, Mr. Carter, because you've never submitted a financial affidavit, and I kind of getting the impression that you don't want to.
Your Honor, may I say something here? I was going off of what you had, then that's why I've inquired so much about whoever filled out the paperwork or had it applied for me to have the attorney at trial. And
The court made that determination on its own.
I understand that. And that's what I come to find that out. And that's what I was wondering is how they became how it was found that because it stated that I was found to be indigent for that process to happen. That's what I was going off of, Your Honor.
All right, if you'll mute yourself again. Okay. That determination was not based on indigency at all, Mr. Carter. That was made based on this court's determination that you may indeed need access to legal counsel. We're going to go over that a little bit more here in a bit, Mr. Carter. But again, that was not based on an indigency finding. It was based on this court's determination there was a need, independent of indigency.
I was just going off of what it said in the order, Your Honor. It just had that stated on the order, that's all.
Well, yeah, that's a boilerplate order that BIDS uses. Sometimes there aren't enough boxes on there to check. But I do wish to clarify that point. It was certainly not based on any determination regarding your financial condition, Mr. Carter.
And that's where I was just confused on how the court was able to find that out and make that determination, because that's all I could read on there was that box was checked. That's where I got that basis from. I'm not saying that I've filled any affidavit out for that. I'm not claiming any of that. I'm just going off of what I read that the court had found in my ruling or on the ruling for me to have the attorney present at trial. That's all, Your Honor. That's
all right. And that's fair enough, Mr. Carter. Again, it was on a BIDS form. Generally, these appointments are based on indigency, but in your unique case, it was not. But that form is what's required by BIDS. So that's what it was submitted on. Further, Mr. Carter, I think this is the proper time to address certain matters. From the very inception of this case, Mr. Carter, you've insisted on representing yourself. And there's a number of advisories I'm going to go ahead and give you at this time. I have advised you all along that you could change your mind and either retain counsel, or if determined to be indigent, you can have counsel appointed to represent you, and you can petition the court for appointment of counsel to assist with your defense. And I do want to make sure that you're aware, even though this court has appointed standby counsel, that once the trial starts, that no postponement of that trial will be permitted for a more active role by an attorney, including your court-appointed attorney who's operating on standby. That at some point during the trial, the court does have the discretion to terminate self-representation if you, the defendant, deliberately engages in serious or obstructionist misconduct before the court in that trial or any proceeding in this court. That the court, once again, I'll inform you, Mr. Carter, that I consider it detrimental for you, the defendant, not to accept or employ counsel to represent you. Even when you were asked for a delay of this morning's hearing so that Chris Pate, your standby counsel, could attend, you rejected that notion. And I understand that you wish to represent yourself and that you have a right to do so. But I think Mr. Pate did want to be part of this, just to know what was going on with the case, since he's being asked to stand by next week. But nevertheless, you wanted to go forward with this hearing at 9 o'clock, and we have done so. Again, I think self-representation is not in your best interest. That if you are allowed to represent yourself, which at this point you are, you must follow all legal rules applicable to the trial of a criminal action. That there's a number of dangers and disadvantages to self-representation, including the following things. That the law provides for numerous pretrial motions available to you, which are of a technical nature, the advantage of which you would lose if allowed to represent yourself. For example, you filed a criminal contempt motion, you didn't know how to serve it, and you didn't even couch it in proper contempt terms because you sought a criminal contempt, and clearly what the remedy you were seeking had nothing to do with criminal contempt. That's just one example that counsel can help you with when it comes to these legal issues. I'll point out to you that your vocabulary and lack of legal training may impede clear communication with the court and opposing counsel. I'll inform you, Mr. Carter, the judges will not act on behalf of a defendant in asserting objections or making appropriate motions, where ordinarily it is the duty of counsel to call such matters to the court's attention. The county attorney, Ms. Norris, will not assist in the defense of your case. Point out to you that the rules of law are highly technical and will not be set aside in view of your status. And that you, as a defendant in a criminal case, may waive constitutional, statutory, or common law rights unknowingly. I need to point out to you, if this hasn't been pointed out to you clearly before, that the maximum sentence for this offense is 17 months in prison. The sentencing range under the guidelines for a level 9 felony with which you were charged is 5 to 17 months based on criminal history, and that you also face up to a $100,000 fine for this offense. So I want to make sure that you realize the possible penalties that can be imposed if you go ahead, represent yourself, and are convicted. Further, the court did appoint standby counsel, a very experienced and very good trial attorney, Christopher Pate. His role is limited. Since you've asserted a right to self-representation, Mr. Carter, he is only there for the purpose of giving advice to you if you expressly request it. He will sit near you during the trial, but he will not participate without the express request of you or perhaps as directed by the court. But I would have to first then determine, before I get involved in that, that you are not competent or qualified to continue with your own defense. Do you have any questions about what we've gone over here, Mr. Carter? Did you understand clearly all of the points that the court has made?
Your Honor, I do and I don't. I have concerns. I have many concerns here. First of all, the attorney that you have appointed for standby, we have been communicating, and in our communications, it is my understanding that I understand that he is there for limited capacity and he's there for just the legal procedure advice, which I've asked him for, which then he gives opinions and then he repeats what he's supposed to be there for. I've only gotten opinions from him and not so much as procedural advice or help with the procedural stuff that I've asked him so far. I don't feel like he's there for I don't feel like he's there for me to help me in any way other than he said that I have to prove my innocence, basically. That's exactly what he said in his email. He said, I have to prove to the jury that I didn't do that and that the bishops are lying. And then he states right after that, he said, well, actually it's the court's or the prosecuting job to to prove that you're guilty beyond a reasonable doubt. So he's more of an opinionated person to me than he is helping with the procedural. He's weighing in on facts or disputes in the case of evidence or whatnot. And I'm not asking him about that. I'm asking him procedural and legal advice for how to proceed or how to file something. And I'm not getting the response back that I need or even anything remotely close to that, Your Honor. I don't know if there's any other standby counsel. I understand, but it's limited to the capacity where it's not opinionated, though, right? I don't need he's not there to give opinions and legal opinions. That's not what I'm asking him for.
Okay. If you mute yourself for a moment. All right, Mr. Carter, his role is quite limited. You're representing yourself in the case. His duty is really at trial It is at the trial proceeding that I want him available as someone who can be accessed by you to provide advice either on procedure or maybe even substance during the course of the trial. As far as being a pretrial resource for legal information or advice, that wasn't his role. I'm glad you two could communicate. That certainly doesn't bother me that you've communicated. But again, you have asserted self-representation. And if you don't wish to rely on anything he said, so be it. You can consider it, reject it. He does not have a role in actively representing you or advising you until time of trial. And I just hope you understand that. He's really only there to be trial standby counsel at this point.
Okay, Your Honor. Well, that's not what he was. He portrayed to me that at that point that he was appointed and by you or the court, that his role was from that point on to assist with me with procedural if needed. He said, I understand that you represent yourself, but I'm here as legal advice or procedural advice on how to proceed all the way from then till through trial and sentencing is what he said. That's what he told me.
All right. So I'm not sure what your ultimate point is here. Please clarify.
Okay, you just stated that he wasn't here for that until trial, but I'm just saying that's why I was asking him what I was asking him, because he made it seem as if he was in that capacity at that moment, not just at trial, is what he portrayed to me. So I'm under the belief, I'm being told one thing, you're telling me something else. He's telling me one thing and he's not giving me the procedural advice or how to proceed or how to file. I'm asking for motional support to file, and you're saying that he's not even supposed to be doing that right now. I understand that, but I'm just expecting. Okay, well, I'm just saying that's what he said that he was there for that as of then. I asked him, I didn't get the response back. I got nothing but mainly his perspective on things and the way he weighed in on legal stuff. And I'm not asking him to do that. I was just seeing if he was trying to help me or not on procedural wise. That's all. And I don't feel like he's there for that. I feel like it'll be the same way through trial with him for some reason.
Court's not inclined to change its previous order regarding Chris Pate's role as standby counsel.
And Your Honor, just so the court is aware, once we got the appointment, we did forward discovery, and any further discovery that has come in, and also generally Mr. Carter emails quite frequently. And when I reply, if I do reply, Mr. Pate has been on the emails so that at least he's aware of what's going on, to what benefit that is to anyone.
All right, Ms. Norris, let me ask you, has there been any attempt for you to communicate with Mr. Carter to try to resolve this case in any way? It's a question I generally ask counsel at time of
Your Honor, no, there has not, but Mr. Carter has not really put himself in a position, or his emails, etc., do not lead me to believe that he has any interest whatsoever in taking care of this case in any other fashion than to go to trial. I don't. That's just the impression I get from the emails and and obviously the motions that he's filed. And there is a motion in limine that I filed yesterday, Judge. It did get filed with just where I emailed a copy to the defendant, and then I emailed a copy to you and your AA this morning on the off chance that you had just not seen it in the Justware queue.
Maybe anyway, will produce that for me here momentarily.
And so, Your Honor, if you wanted to ask Mr. Carter about the possibility of resolving the case, I just have never gotten the impression that he's even remotely interested. So I would say that discussion has never occurred.
All right. I'm going to take a 5-minute recess at this time. We're going to put you two in a breakout session. And I want you two to at least discuss the possibility of it.
Yes, Your Honor.
We'll come back on in 5 minutes. If you need more time, perhaps the court will extend the the conference time, but I want you two to at least have had the opportunity to talk, as is traditional, as part of this pretrial conference docket. So I'm going to go ahead and stop recording and broadcasting at this. Following a recess to allow a conversation between Mark Carter representing himself and prosecuting attorney Amber Norris, the court resumes proceedings in case number 2023 CR 194. I'll also note that Chris Pate, who's the standby counsel for trial purposes only that the court appointed, has now joined the meeting. Ms. Norris, following this opportunity to discuss possible case resolution with Mr. Carter, what would you announce at this point?
Your Honor, that there is, and probably won't ever be, a chance, really, I don't think, for this case to be resolved outside of a trial situation. We had some discussions and we had a hard time staying on topic. But yeah, I don't think that there's any way that there will be any kind of a plea in this matter to the point where the defendant is, talking about civil action after this case.
All right. All right, there are a couple of motions still before the court at this pretrial conference that the court needs to address. Mr. Carter, your motion for transcript of court proceedings held on Zoom. Number one, as the court referred to earlier, there's never been a finding of indigency. So as far as your claim that you can't afford the transcripts, the court doesn't have any information before it to verify that.
Can I say something, Your Honor?
Go ahead.
Okay, I'm going to say that I already had the paperwork filled out to file. I just can't drive over there. It's a lot of gas from Viola area to El Dorado, of course. That's a pretty good long distance away from me to drive over there to file paperwork and then leave and come straight back. I did not file since the order was for Chris to be my attorney because of, like I explained earlier, the indigent thing was attached to the order that you made, and where it was, the box was checked off for that, and I assumed that that was the way it was going to go for, and that I could be found for that to get the transcripts at this point. And it was a mere obvious misunderstanding of what the judge, of what you had ordered, and the boxes checked and whatnot, finding the indigent, but it's actually not found indigent. I can attest to you here today, any financial statements that you would require for me to fill out on form, I could, under oath, whatever you need me to do. But I can attest to that I am an indigent defendant at this point, that I cannot afford the amounts or anything close to that for the transcripts, but I desperately do need these transcripts for trial due to the fact that they do have the testimony of the 3 witnesses that the state has brought forth to get this action and keep it going to trial. And in those testimony, the officer Shiner has perjured himself several times on several notes, clearly on from things that Ms. Norris has asked him and things that I have asked him. His responses, and I've clarified it with him 2 to 3 times during that testimony of his answer, and my ring video clearly are in total 100% contradiction to what he has stated on as far as letting the Tim and Kim Bishop search through my stuff or assist in the search. He's testified that they were not there they didn't assist in anything. They didn't search through anything. He testified that he was there and searching and that they were looking over his shoulder. Now, the ring video that I've submitted to Ms. Norris, she's got it. It does show that the Tim Bishop, Kim Bishop searching through my stuff without the police even in the presence of them, like there. You can just hear them in the background off to the side. They're not searching through anything, but Tim and Kim are. And if anything, it shows that the police are looking over Tim and Kim's shoulder as they're searching. That's just one thing. There's obviously Kim has taken videos and taken pictures on her iPad. He testified Shiner testified that she did not take any photos there. She wasn't allowed to have an iPad or anything, only to show him pictures. Tim has testified that she didn't take pictures, and Kim testified she didn't take pictures. Now we have the email chain.
Okay, so not only is he a wackadoo, but he's got a bad memory because she specifically said she took pictures and compared them later. I remember that from months ago when I watched it, and I could rewatch it and clip that if, he needed me to.
Where Shiner is getting and requested the photos that she took, and we're waiting on those photos now. He's admitted to it, and so is Kim.
Mr. Carter, these witnesses would have to testify all over again at the trial. If you have some sort of evidence to challenge the credibility of their statements, you can present that at trial, can't you?
Yes, Your Honor, I can, if they state the same thing they testified to in the first one. But if they change their testimony at the trial to exactly what the video shows, that doesn't show my perjury, which I have it on. If we have the transcripts, it will clearly show contradictory 1,000% to everything that actually happened. They didn't know I had Ring video, obviously. It has Ring, and it has audio and video, and it rolls 2-minute clips at a time. Every time there was a motion, and it pretty much, it doesn't skip a beat through any of it for the good portion that anybody's up there close to the camera. I have every bit of it, like the entire day, that whole afternoon, all the way up till almost midnight, to where they're there going through the stuff, and it goes against everything that he claimed and they claimed in testimony before you in the court under oath, Your Honor. It's clear as day.
I'm not aware of any authority that absolutely requires a preliminary hearing transcript to be prepared. Court can consider alternatives to preparation of transcripts. I can set up giving you access to the Zoom record on Monday afternoon if you so desire.
Oh, that would be great.
You'd have to come to the Butler County Judicial Center here in El Dorado.
Oh, and Judge, I wasn't aware that you actually still had those.
Excuse me?
I wasn't aware that you were actually keeping the video.
Yes. Well, yes, we are. It should be available.
That'd be more than I could ever ask for, Your Honor.
All right. What time would I tell them that you're going to be here? I think that's probably a couple of hours, 2 or 3 hours worth of testimony total. Can you be here at 1 o'clock?
I could be there in that morning.
All right. What time in the morning?
10 o'clock.
All right. We'll have somebody contact you by email if that won't work. You'll have to go to the place in the Judicial Center that's designated for you. Obviously, I'll expect you to take care of any equipment that the court is using to display the Zoom recording. So I'm not going to allow any substitute video be introduced at the trial. So just in case you're thinking about recording what's on screen, you could do so, I suppose, for your own purposes, but it's not going to be admissible at trial. The only recording that would be admissible would be the Zoom recording itself. And then even then, you'd have to meet certain requirements as to whether that's even proper or not under the circumstances of the case. I'll reserve ruling on that. But I'll try to set up at 10 o'clock on Monday to have you get access to the preliminary hearing record. All right. With that dealt with.
I just have a few questions, Your Honor, about the evidence in the trial on introduction of it. And I understand proper procedure and everything. I don't understand why it wouldn't be allowed for me to introduce during questioning of a witness of the state, should I say, at this point, a witness of the state, of their actual being recorded on my Ring camera and things they're saying, and it shows their picture of them, and have them testify as to that video being accurate description and representation of them in that day and what they're saying. Are you saying there's no way I can actually have that brought into evidence?
I didn't say that at all. I was talking about the Zoom recording video. That's what I was saying.
I understand. Okay,
Not,
okay.
not some independent video that might be determined relevant. No, I haven't ruled on that.
Okay, that's all. Thank you.
All right. The motion in limine filed by the state still needs to be addressed. What they're attempting to limit is that apparently defendant filed a PFS, a protection from stalking action, against the bishops, who are, I think, the alleged victims and will be witnesses at the trial. Apparently they haven't even gone to final hearing yet. State's position is any information regarding these PFS cases would not be relevant and would not be material to any issue in the trial. And they're objecting to any reference to the existence of a PFS case. And apparently that's a Sedgwick County case.
Your Honor, they keep coming out here to my residence all hours of the day and night, making noise and ruckus, harassing me and my family. And I filed a PFA.
What does that
We
have?
had the hearing. Well, the thing of it is a character flaw because their characters at question when they're on the stand, Your Honor. When they're giving testimony, their characters at 100% question. This is a part of that file of their character. Their character is they're coming from Andover, Butler County, a separate county from here, all the way to the far extreme southwest corner of Sedgwick County just to drive around my place and harass me and my family at all hours of the night and day. Tim even admitted it to the judge, and the judge in that court actually found it enough to keep that order to remain in effect for them not to come out here and harass me anymore, Your Honor. It is an order, and the judge only continued it till after the trial of this matter here is taken care of. And he didn't know the exact date, and he didn't know how long, he knows, I guess he had experience with Butler County's trial dockets taken and sometimes extending out longer than they had been because of the COVID-19 issues going on. And he wasn't aware of anything changing since then and how it was going right now, to the effect that he didn't know exactly when the trial would actually commence and be finished. And so he gave it a little bit of a leeway with the November date of the hearing actually being held, but he did take into account the evidence that I submitted and showed him. Tim admitted that it was him on the video, of all the videos I showed him, and the judge made his ruling.
The problem is the ultimate issue for the jury to decide is your guilt or innocence regarding felony theft. Their behavior toward you subsequent to the filing of these charges, I don't see the relevance at all. Carter, all
They're
all
victims.
you do is get distracted on issues that have nothing to do with the issues that are really there for trial.
Your Honor,
nothing you've said has convinced the court that the motion in limine should not be granted. I don't want to
Your Honor,
protection orders.
Your Honor, may I say something else here?
You may.
The reason it should not be excluded from this due to the fact that that is a character issue. If they're alleged victims in a case that is proceeding before the jury right then, the jury has the right to know the character and the actions of those people that are portraying to be a victim in a case that is trying to get me put in jail or fined and all this other stuff, found me guilty of a felony. So their characters at play here. They're out here harassing me. It has been found and extended to go into and remains in effect. It says it right here on the order. Remains in effect, Your Honor. Both of them, both cases. Kim and Tim separately filed. I filed separate ones because of their harassment to me. Now, it should be allowed that their character come up in court. And it is my right to bring their character up against any witness the state
Wait a
brings forth.
minute. If you're going to say it's your right, what is the authority behind that statement?
My constitutional right to have to question the witnesses before me and their character, Your Honor.
Character evidence in Kansas is limited by statute. There are only certain instances the character can be brought up. We don't try cases based on the character.
I'm not asking you to. But the victim's character in the case where they're claiming to be victims in a matter before the court, claiming that I have stolen something from them, whenever there's evidence that shows that I have not, and their character where they have actually perjured themselves, which I will be able to prove, their character will all be at the show of the court and to the jury. If they've perjured themselves, and I can prove it in the court by the testimony that they've given already, And what they say in court that day, it just depends on what they say that day but it'll be perjury either way because of the records that the officer's got in his notes with my ring videos that I can introduce. If it's there, Your Honor, the case will not proceed. The victims, the alleged victims in this case are lying. I do have the evidence of that. They have came out here, harassed me and my family at all hours of the day and night. That should be allowed in this case, especially make the determination at that time is what I'm asking you, Your Honor. After, I won't even introduce it until after I've shown the perjury and laid my foundation for my case. I'll introduce it at the right time after that, and you can make that determination then. Can I ask you to do that, Your Honor?
I don't want any references made to this during jury questioning, during opening statement, or any other part.
The end of the video got cut off a little bit, but there was nothing else said that was super important other than you're going to trial. I'm not granting your motions. And he tried to get him to stop. So this was a couple days ago. It was just right at the end of last week, and it gets even better. He filed a motion yesterday. Trial's supposed to start today. Trial's supposed to start on the 3rd. He filed the motion on the 2nd. The motion to dismiss, motion to suppress evidence, motion to return seized property, which is his welder, motion to request a change of judge, statement of facts, and affidavit of memorandum. Like, what on earth, dude? There's just so much that I'm not even going to go through this whole thing. It's laughable, and I'm sure they'll have a hearing on it, and we'll cover it there. If you want to look it up, you can look it up on the Kansas court records and just search for Mark Carter and refine it by Judge Ricke's name, Ricke. Yeah. To be continued.
Okay. So now we're at the present day, and Mr. Carter is in the Butler County Jail. This is because early in January, there was a hearing held, a jury trial, and Mr. Carter was convicted of theft. He was sentenced to a year of probation, and Judge Ricke added on 60 days in the Butler County Jail, which he will explain later on in this hearing. Mr. Carter has decided that it might be smart to, allow that standby counsel to actually do his job. So he's filed a motion for a new evidentiary hearing, alleging that there is new evidence based on the Ring camera footage from Mr. Carter's house that shows that his former employers participated in the search of his property, which they did testify to, if I recall correctly, saying that they did participate in the search, but that they were supervised by law enforcement. There was a lot of confusion. I think that happens when pro se defendants are involved and there's a lot of emotions. Anyways, so this motion is being heard in front of Judge Ricke, and it is a motion for a new evidentiary hearing. All of the documents related to Mr. Carter's trial, including jury instructions, are posted on my Patreon if you're interested in reading the details and the motions and whatnot. The link to that's in the description.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Mark Carter. It's case number 2023 CR 194. Mr. Carter appears from the Zoom location at the Butler County Detention Center. Chris Pate appears as has been his traditional role as standby counsel in the case. I trust you're more actively representing Mr. Carter at this stage, Mr. Pate?
Your Honor, after the sentencing hearing on January 2nd, Mr. Carter asked me to file a motion on his behalf, which I have done. And I've also taken the steps of filing a notice of appeal, and I've obtained an order appointing the appellate defender, which I believe was approved yesterday. So I'm also going to be doing all the necessary work on my end to make sure the appellate defender gets what they need to handle the appeal.
Understood, Mr. Pate. Thank you. Let the record reflect Amber Norris appears for the state of Kansas. Court has before it a motion for appeal bond or stay of sentence. I don't show a filing date on that document, Mr. Pate, but I have been provided a copy of it, and I trust Ms. Norris has as well. you may proceed further on that motion at this time.
Thank you, Your Honor. As everyone recalls, on January 2nd, the court granted Mr. Carter probation, sentenced him to a 7-month underlying sentence with 12 months of community corrections. However, the court did impose the 60-day jail sanction as a condition of probation, which Mr. Carter is serving. He was taken into custody immediately following sentencing and has served in the neighborhood of 20 days in between the time post sentencing and then also the time that the court revoked his bond prior to sentencing to get the pre-sentence investigation done. As I stated previously, I have filed a notice of appeal for Mr. Carter's request. I have obtained an order appointing the appellate defender, so I expect an appeal will be in process here very soon. This is one of these cases, given the nature of how long it takes to work through an appeal. My guess is if we have a ruling from the Court of Appeals within 12 months, that might be optimistic. By the time we get to that point, Mr. Carter very well may be off probation, or even if an underlying sentence got imposed, he would have long since served that sentence. He certainly would have served the entirety of the 60-day jail sanction that the court imposed. As also evidenced by the PSI, Mr. Carter is a criminal history I. While he does have some misdemeanor criminal history, the majority of that is over 15 years old. The majority of that appear to be traffic offenses and then dog license offenses and things of that nature. So he's got very limited criminal history. He has no prior felonies. He has no person crimes, violent crimes, or anything of that nature. So I believe his risk to society at large is very, very low. As he also argued at the time of sentencing, he does have a family to support. His wife is not in position to really hold employment. He was in the process of trying to find work at the time the court imposed the 60 days. So for those reasons, we would ask the court either consider one of three things. One, some type of reasonable appeal bond, so Mr. Carter can be out on bond while his appeal is handled. Obviously, if the appeal is not successful, then the court can reimpose the sentence. In the alternative, we would ask the court to issue a stay of the sentence, including the 60 days pending the outcome of the appeal. I would also make an oral request to the court for a reconsideration of the 60-day jail sanction. While I understand what the court's logic was in imposing that sentence, Mr. Carter has now spent basically 2 separate 10-day stints in the Butler County Jail. If there's, I guess, for a lack of a better term, any type of shock treatment value for that for an individual like Mr. Carter that's really never spent time in jail, I'm confident that the court has very clearly delivered that message to him, and that he understands that he needs to conduct himself in a law-abiding manner moving forward. While Mr. Carter disagrees with the outcome of the trial and he disagrees with the court's rulings, he respects the court's authority, and even though, again, he maintains his innocence, if the court reconsiders that and he is outright placed on probation, he fully intends to comply with that while he's handling his appeal in the event that the court does not grant a stay. So for those reasons, we would ask the court consider one of the options of relief that we've presented today.
Well, thank you, Mr. Pate. Ms. Norris, the state's position on this request?
Your Honor, we would ask that the court deny all 3 requests. Don't believe an appeal bond is necessarily appropriate, and a stay I think is completely inappropriate. And as far as reconsidering whether the court gives defendant jail time, the court did that of its own volition. And in its own discretion, and I would leave it to court's discretion regarding the reconsideration. He has now served 20 of the 60 days that the court ordered. I don't believe that the sentence that the court gave was out of bounds or inappropriate or illegal in any fashion. So I would ask that the court deny defendant's respective, motion and 3 options.
Very well. I understand the state's position, Ms. Norris. Court imposed a 60-day jail sanction as a condition of probation in this case, as the court recalls, for several reasons. Generally speaking, Mr. Carter's lack of genuine remorse shown at any time during the proceedings, including sentencing. He took no true acceptance of responsibility for his criminal conduct. And he, at sentencing, presented no plan for restitution. In other words, no plan to make things right with the victim in this case. Further, this court, throughout its judicial career, has, in similar cases, not necessarily as a matter of policy, but have often imposed 60 days jail as a condition of probation in cases where there's been a violation of trust by an individual, the perpetrator, causing the victim of the case substantial financial loss. Those factors are present here. So this certainly wasn't Mr. Carter being singled out for treatment, but rather one that the court, it's a position that the court has taken often in similar cases. Further, if this court were to grant an appeal bond in this case, it would essentially remove the deterrent effect, and punishment for bad behavior would certainly be diminished if the court were to simply release someone because they filed a notice of appeal. Further, the court notes in this case that Mr. Carter's entire defense at the time of trial was oriented toward count 1, the felony theft charge. He essentially presented no defense regarding count 2, refusal of a biological sample. Even if Mr. Carter were successful in attacking his conviction on the felony theft, which his entire defense was centered around, he still would have a misdemeanor conviction for a 7-month sentence on the refusal of a biological sample. A 60-day sentence is certainly authorized on the misdemeanor alone. And under the facts and circumstances of this case, the court is not inclined to grant an appeal bond in this case. The court also denies the request to issue a stay of sentence in this case, and further denies reconsideration of the 60-day jail sanction that was originally imposed. The court believed at that time that it was appropriate under the circumstances of the case, and still does. I would see 19 days jail time credit already served, 10 days as of the 2nd. It's been 9 days since, but nevertheless, the computation of jail times left to the jail officials, and I know we're in the ballpark that he served about a third of the 60-day sentence that was originally imposed. So, Mr. Pate, you've argued the case well, but the court declines to grant any of the relief that you've sought under your motion. Mr. Pate, is there anything else that we need to address currently?
Not from my end. I would note for the court, Ms. Norris did send in some case law on the issue of restitution, because the court at the time of sentencing limited the restitution to $24,999.99 because that was the top end of the level 9 charge. In all candor to the court, I have not had time to review what Ms. Norris sent in. I'm not faulting her, but it came in at the end of the day, and then I was in court all morning. So our request would be that the court not disturb restitution, and then that can be dealt with on appeal if there are appealable issues. But if the court is inclined to entertain further argument from Ms. Norris on increasing the restitution, I would need some time to review what she sent and prepare for hearing on that matter.
Court also has not had the opportunity to review any case law that may have been submitted by Ms. Norris. I don't doubt that she may have submitted it to this division, but I haven't had an opportunity to see it. before the court would modify restitution in this case or consider same, a motion would need to be filed by the state and set for hearing. And then I think the defense would have a fair opportunity to argue against such increase of restitution should the state believe at that time that that's appropriate and necessary. So that issue, if there is one, remains unresolved at this time. At this point, the restitution order as originally made at sentencing stands, subject to further modification consistent with what was announced at sentencing. Very well then. Ms. Norris, anything further the court needs to address at this time?
Your Honor, I do have a request, and it's in regards to all the property that is in evidence with law enforcement. The victims were curious about their ability to get any or all of it returned at this time. And I wanted to make that request to the court at this point.
Well, as long as it's all properly inventoried and identified before it's released, court's certainly open-minded to that, but this is an unresolved case, which apparently will be on appeal. Your position on this, Mr. Pate?
Well, Your Honor, I know Mr. Carter has maintained from the beginning that several of the items that were seized were without a doubt his, and I'm not talking about items that Mr. Carter argued were stored with his permission and sold. I know that there were certain items where I believe there was just absolutely not a dispute that they belonged to him. And what I don't want to see is things that are truly his getting handed over to someone else or disposed of. So whatever we need to do to protect his right to that. So I guess I would ask nothing be released at least until Mr. Carter's out of jail. That way he can prepare an itemized list of what he believes is truly his. And then I can resolve that with Ms. Norris, because I think there were certain items that she agreed and maybe law enforcement agreed belonged to him. I just want to make sure he gets back what is absolutely without a doubt his.
Your Honor, there was only one item.
A long list of items or just one or two?
I don't know, Your Honor. I don't have a list. I know there were certain items that Mr. Carter had stated repeatedly were his.
And Your
Mr.
Honor, there
Carter
was
should
one
get that
item.
property that belongs to him. All right, Ms. Norris?
Your Honor, there was one item that that we after talking with law enforcement and doing some additional research, we did allow to be released, and that was a toolbox. That is the only thing that anyone, at least from state's position, that could possibly be defendants. But I would say that there are items that have the bishop's either their name or the name of their company, actual like a label on the items that are some of those that are in evidence. May those be released?
Mr. Pate?
If it's items that are marked with the bishop's information, I suppose I don't have an objection as to that. And I mean, I guess it could become a civil matter after that, but I just don't want anything that is without a doubt Mr. Carter's released to someone else.
All right. That appears to be a practical approach, Ms. Norris, and the court's inclined to adopt your suggestion. To the extent that there are items being held by law enforcement in custody involved in this case that actually bear a label of the employer, the bishops, or their business name, those items should be released immediately to them. Furthermore, if there's a clear consensus of anything that's Mr. Carter's that hasn't been released, that should be released to Mr. Carter. Obviously, he's in no position to pick it up at this time. This toolbox that was released earlier, did he pick that up? Mr. Carter, do you have that?
Yes, I did, Your Honor.
Okay. All right, so that one item where apparently there was an agreement is not at issue anymore. To the extent that there are items in custody that do not bear a specific label or marking, the court will order those to continue to be held at this time until at least there's some opportunity for counsel to confer and perhaps reach an agreement as to what should be released and what not. But the items that are clearly marked for the employer or the bishops should be released to them without delay. And I trust Ms. Norris, you'll prepare an order in that regard.
Yes, Your Honor. Do you want me? I know that it was defendant's motion, but now I've made a motion. Do you want an order just on the property from the state?
Why don't you go ahead and include in that order just a concise statement that the three requests for relief that were made today were all denied by the court at this hearing?
Yes, Your Honor.
That would avoid duplication of efforts, I think. So thank you
And,
for doing that.
should I be forwarding that to Mr. Pate for signature?
Yes. Yes.
And from this point forward, is my communication with Mr. Pate?
In the view of the court, yes, until an appellate defender is actually actively involved in the case. Mr. Pate, any issue with that?
Nope, that's fine with me, Your Honor.
Yes. Thank you for that question regarding clarification there, Ms. Norris. All right, anything else, counsel?
Your
Nothing to
Honor,
say,
just
Your Honor.
for the record and for Mr. Carter's benefit, I will continue taking the necessary steps to make sure that the appellate defender gets fully involved to perfect the appeal.
Thank you for those efforts, Mr. Pate. Ms. Norris, anything further?
No, Your Honor. Thank you.
Very well. At
Thank
this
you.
time, then, the Mark Anthony Carter matter will currently be in recess, and this